Mr. S. Bora, the learned counsel appearing for the accused applicant, submits that the matter may be adjourned for a week as CD is yet to be received. Let the matter be fixed in the next week.
But there is an interim order that is continuing.
Next week on
Anytime, anything.
25th, my lord.
25th.
So there is an interim order.
Interim order so passed earlier shall continue till the next
Right.
week. Yes,
May it please your lordship.
Mm.
Lordship, I beg to mention item number 20 of today's list, my lord.
20,
20, my lord.
20.
20.
Ah.
And for the respondents, my lord, I have taken consent for the counsel for the petitioner, my lord.
Hmm.
My lord, after a week, my lord, you want to
Okay.
file a reply.
Mr. DK Buddha. Praise for adjournment of the matter. DK Buddha appearing for the respondent, praise for adjournment of the matter with the consent of the other side. Let the matter be fixed on,
After a week, my lord, as per lordship's continues. Week or 2 weeks, my lord.
maybe in the first week of March.
LCR also not has come, my lord.
Huh?
LCR also not come. my
LCR
lord.
not come.
Reminder may be.
Matter be fixed on 5th. Registry to send a reminder for the TCR in the instant case.
Deeply obliged.
May I please, Lordship, item number 53,
Hmm.
order matter, my lord, I file you additional affidavit. So this requisition is required to bring the record.
Okay.
So for item number 36 is concerned, lordship. Item number 35 is also the same person. Yeah, 35 has filed earlier, lordship, and I have filed subsequently, lordship. So I want to withdraw that item number 36.
36 you want to withdraw?
My
Yes,
lord,
lordship.
interim was not granted in 35, subsequently that 36 also filed. Same person.
Same person, lordship. He has misled us, lordship. The petitioner has misled us. He has not informed that
35 what happened?
35
35
CD has
was
been filed.
listed today, interim not granted, subsequently 36 filed, my lord. Same person, same PS, my lord.
Same.
Okay. Mr. The learned counsel, Mr. Ardhar appearing for the petitioner submits that the instant bail application has been mistakenly filed as a bail application is already pending in the already pending in connection with the same FIR.
Yes.
Same FIR. Prayer is allowed. The case is, the bail application is dismissed as withdrawn.
Deeply obliged.
May I please your lordship. Item number 30, lordship.
30,
The engaged counsel is out of station, lordship. So, meet my passport for the day, lord. Any date, lordship.
let the matter be fixed in the first week of
30, 30.
30.
The early interim.
PD has come,
Charge sheet submitted, my lord.
charge sheet is submitted. Let the matter come. Let the matter be listed
I am not in a vocal number, lordship. Let it some other day, lordship.
day after tomorrow.
Yes, sir.
On the prayer of
Early interim.
the learned counsel appearing for the accused applicant, let the matter be listed on, it will be on 18th. 18th.
Yes. Early interim may continue.
Interim order so passed earlier shall continue.
Obliged.
My lord, item 2 may be adjourned, my lord. Can you next week?
Okay.
Mr. Ichar Chaudhary, prays for adjournment of the matter for a week. Let the matter be listed on 25th.
My,
May I please the lordship? I beg to mention item number 39, my lord. It is a revision against conviction and fine, my lord. Last time, your honorable court directed the petitioner to deposit rupees 25% of the total amount, that is 7,50,000, and he has deposited 1,87,500, my lord, on 12 February. My lord, I have mentioned this matter because I have a very urgent hearing in family principal judge. So if the matter maybe come up in this time, my lord, so maybe it taken at after 3 p.m. or within
Which one? Which one?
item number 39, my lord.
So it will come in usual course.
Yes, my lord.
It will become, it will be heard. If it reaches,
But
it will be heard.
Money is deposited, my lord.
That's fine, that's fine. 39 will take up when the matter comes.
Yes, my master.
May I please your lordship? I beg to mention item number 10. Matter may be adjourned, my lord. My senior is out of station.
Why?
Medical emergency office father, my lord. It may be fixed on 23, my lord.
A prayer has been made by the council appearing for the accused applicant for adjournment of the matter because of due to some medical emergency. Let the matter be fixed on 26th. 26th.
May I please, my lord, I beg to mention item number 15, my lord, 15, my lord.
Hmm.
My lord, I am for the petitioner, my lord. Here some developments are there, so I have filed one application for amendment of the writ petition, my lord. So I pray that this matter may come up after 2 weeks along with the IA. I am going to file today, my lord.
Mr. A.K. Gupta, learned counsel appearing for the accused applicant, has submitted that he has filed an IA for amendment of the writ petition. He prays for 2 weeks' time. Prayer is allowed. Let the matter be fixed after 2 weeks.
Okay.
May I please, your lordship? I'm mentioning item number 12
12.
for
Mm.
adjournment of the day because my senior is out of station. Kindly, it can be fixed on 18 or 20, your lordship.
Mr. Ms. So-and-so, the learned counsel appearing for the accused applicant submits that that the leading counsel in the instant case is out of station. Let the matter be fixed on 25th,
20. 20.
20th. Okay, 20th,
Deeply obvious. May I please, your lordship? I beg to mention for list.
20.
I beg to mention for listing of a AB lordship.
When?
On last occasion, it was fixed for today lordship, but it didn't listed for today's list.
When do you want? Day after tomorrow?
Day after tomorrow lordship.
Day after tomorrow?
Obliged.
May it please, your lordship, I beg to mention item number 26, lordship. Kindly pass over the matter for the day and fix it on next week, lordship.
Which one?
26.
On the prayer of learned counsel appearing for the accused applicant, let the matter be fixed. Let the matter be fixed on, when do you want?
Mas-
After a week. Let the matter be fixed on 24th.
Mass oblige, lordship.
May I please, your lordship, I beg to mention item number 11, your lordship. Kindly, matter may be fixed after 2 weeks.
11.
AB application, why 12 up to 2 weeks? AB application you have filed and after 2
My
weeks.
senior is not keeping well, your lordship.
Hmm?
My senior is not keeping well.
Who is your senior?
Jed Alam.
Okay, the learned counsel appearing for the accused applicant submits that the leading counsel in the instant case is not keeping well. Prayed for adjournment of the matter for a week. Let the matter be fixed on 26th.
May I
26.
oblige, your lordship? May I please, your lordship? Lordship, I beg to mention item number 48 of supplementary list, lordship.
Hmm.
We're filing our objection to their lordship. It may be called for lordship.
Okay.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 50 of the supplementary list.
Hmm.
Lordship, matter may be withdrawn, your lordship. Will approach the lower court, lordship.
Okay. You're Mr.
A. Ghoshal.
Mr. A. Ghoshal, the learned counsel appearing for the accused applicant submits that he has instruction to withdraw the instant bail application. Prayer is allowed. The bail application is dismissed as withdrawn.
With liberty, lordship.
We dismiss that withdrawn. You can go and liberty is always there.
Obliged, lordship.
May I please, my lord, I pray for listing of a regular bail application for motion, my lord, if possible on Wednesday, my lord.
Okay.
Okay.
May I please, your lordship? I beg to mention matter for listing criminal petition, my lord.
When?
Any day next week, your lordship.
Next week?
Yes, lord.
Okay, 24th?
Yes.
Maybe your lordship. The petitioner went to withdraw.
Your name?
Yeah, Islam.
Mr. A. Islam?
Yes.
You are not there in the case?
Anarul Islam.
Okay, yes. Mr. A. Islam, the learned counsel appearing for the accused applicant submits that he has instruction to withdraw the instant bail application. Prayer is allowed. The bail application is dismissed as withdrawn.
Wait, please, your lordship.
heard Mr. So-and-so, the learned counsel appearing
Lordship.
for the accused applicant. This is an application you write, huh? Application, the matter relates to
Lordship, the petitioner has been languishing in jail since Lordship 87 days, Lordship. Here, the statutory period is 60 days. I'm able to take instruction whether such is submitted
60
on.
days?
Yes, yes.
for POXO what? Section
Option 10 and 12.
10 and 12,
Lordship,
okay.
the petitioner could not see anything, Lordship,
Hmm?
by his naked eyes, Lordship. He's a
Petition-
blind person, Lordship.
Also, blind person cannot do this kind of offenses. It's possible. It can be done. I mean, we'll wait. I mean, if mandatory
after
period
some-
is there, then you may get a default.
After
bail.
some time, my lord,
After some time, we'll take it up. Okay.
I have already talked, my lord.
See, mandatory detention period may be 60 days.
Yes,
I
Lordship.
mean, without filing charge sheet.
Yes, Lordship.
So if it is 60 days, if charge sheet is not filed, you will be liable. I mean, you have a right to get default bail. So wait for some time.
Yes, Lordship.
Correct? You are there in the case? Or who is appearing in the case? You are leading the case.
Yes, Lordship.
So you are not aware of default bail.
I know, Lordship.
Huh? Are you aware or not default bail?
I'm hearing about this.
What is default bail?
Lordship, if the charge sheet is not filed within the statutory period,
Huh?
then the petitioner.
So in your case, I mean, whether subsidy is filed,
Charge sheet, as per our information, charge sheet has not been filed today.
then you get a right. You are not aware of that.
Yes, Lordship. I
You
am.
should be aware of that. See, otherwise the clients will suffer, Mr. Counsel.
Yes, Lordship.
And now the PP has pointed out, otherwise
Years and 7 years, 7 years and 3.
you should go through all these things.
Yes, my lord.
We'll take it up after some time.
After some time.
May I please, Your Lord?
Yes.
483 application, intermediate quantity, my lord. In fact, petition number 2 is no way connected, my lord, at all. He was traveling in a different car. But during Naka checking, police suspected that he is also.
We'll call for the CD, Mr. Biswas. We'll
Short date, my lord.
heard Mr. S.C. Biswas, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned counsel, learned APV for the state. Reason application you write, the matter relates to recovery of, what was the quantity?
Quantity is, my lord, 182 grams,
182 grams of
heroin, my lord.
suspected heroin. Call for the CD, let the matter be fixed on.
From Dimahasa, my lord.
26.
Okay, 26th.
Please, Your Lordship. Such a matter pertains to commercial quantity, 505 gram of morphine. Test diary will be required, Lordship.
Okay, heard Mr. D. Medi, learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state. Matter, this is an application under so-and-so. Matter relates to recovery of how much?
505 grams of
505 grams of
morphine.
morphine. Suspected morphine. Case, let the, call for the case diary.
2nd of March.
Let the matter be fixed on 2nd of March.
Deeply obliged.
May I please? Lord, charge sheeted case, my lord, Lordship will find page FIR 10, page 10, my lord. TCI may be called for, my lord. Murder case, my lord.
Okay, heard Mr. So-and-so. Learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state.
From Dibrugarh.
Hmm?
From Dibrugarh. Sessions case number 350.
Okay.
Page 2.
Matter relates to at least commission of rape. What was the allegation?
Murder, my lord.
Murder?
Yes,
Okay.
Madam.
Relates to commission of murder. Commission of murder. Registered to call for TCR in the instant case. from the Court of the Additional Session Judge, Dibrugarh, Assam. Dibrugarh, Assam. Let the matter fixed on when
5th of March.
5th of March.
May, with your lordship.
Yes.
Your lordship, so only offense that has been cited in the FIR lordship is that petitioners found in possession of 3 numbers of street dogs, lordship. Page 9 is the FIR lordship. And on 5th, these 3 street dogs were in the vehicle of the petitioners.
Niranjan Rao.
Page 9.
Yeah.
Old flowers. Somebody's old flower. See. Now, where is the involvement? I mean, is there any involvement? You see?
Malad, 3 dogs were found in their possession. That Malad.
Street dog.
No, where is that? I could not find it.
No, Malad, not in the FIR, Malad in the
In a forwarding also where?
forwarding, Malad.
That is their lordship.
That is there, Malad, grounds of arrest, point number 4.
Page number 14, lordship. During investigation, 3 numbers of steel street dog were recovered from the possession. No, not really.
No. Heard Mr. T, heard MSP Som, the learned counsel appearing for the accused applicant, also heard Mr. KK Parasar, learned APP for the state. This is an application under so and so. An FIR was lodged by one animal lover, namely FIR was lodged on 2nd December 2025 by one animal lover, namely Pyomjuti Fukon, alleging that the street dogs in the state street dogs in the neighboring area of neighboring area, and then street dogs of various areas in this town of Lakhimpur, started disappearing, full stop. He being an animal lover, he has inquired about the matter and found that several dogs from various localities have been disappearing in recent few weeks. In view of the aforesaid, he filed the FIR before the officer in charge, North Lakhimpur Police Station, Lakhimpur, to do an investigation about the missing dogs. The police, after next para, after registering the aforesaid case, after registering that, 1 second. After receipt of the FIR, North Lakhimpur Police Station case number 435-2025, under sections 11 in bracket 1 bracket small d of the Prevention of Cruelty to Animals Act was registered. And after investigation, police recovered 3 dogs from the three stray dogs in possession of the accused applicants. Thereafter, the police forwarded those persons to produced those persons to Chief Judicial Magistrate North Lakhimpur on 6/2/2026, and thereafter the accused applicants are in judicial custody.
Yes, Lordship.
Are in judicial custody. Full stop. The learned counsel appearing for the accused applicants submits that the accused applicants are no way linked to the aforesaid aforesaid allegation of missing dogs. Rather they have kept those dogs due to their affection to the dogs, due to their affection to the dogs, and they are not involved in any killing or smuggling of dogs for the purpose of eating, full stop. Taking into account the end effects of the case, this court of the considered opinion that that the accused applicants should be granted bail at this stage. Accordingly, it is directed that the accused applicants should be released from judicial custody on furnishing of bail bond of rupees 20,000 each, with a surety of like nature to the satisfaction of Chief Judicial Magistrate
Not looking.
Lakhimpur, Lakhimpur, subject to the following conditions: that the accused applicants shall not indulge in any kind of allegations as alleged in the FIR. The accused applicants shall appear before that investigating authority if the same is required. In any view of the aforesaid direction, the instant bail application is disposed of.
FIR, Your Lordship will find at page 8. Your Lordship, the daughter committed suicide and the father and stepmother is in custody, Lordship. In the FIR, there is no allegation of instigating or how they have instigated. That part is missing, Lordship. And the
So we'll see the case diary, Mr. Rajan. It's a case of suicide and suicide.
in case of suicide, there has to be direct.
There has to be, but the suicide was committed in the house, right?
Yes,
House,
they are the parents.
So they have already been taken in custody.
Yes.
So we'll see the CD, let's see. I mean, we'll keep a short date. I mean, I don't know why the parents have been, there may be some allegations there. We'll just,
Torture
Mm.
is there.
let's see what is there in the CD.
Stepmother.
Heard Mr. Ahmed and the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasol, learned AP for the state. This is an application under so and so. The case relates to suicide of the victim in the house of the accused applicants. who are,
Parents, father and stepmother.
who are the father and stepmother. Stepmother is also involved, who are the father and that
Stepmother.
customary thing. The general perceptions. Then I'm not commenting anything but general perceptions. We'll see. This call for the CD and let the matter be fixed on.
Okay, matlab 26.
Okay, 26th will, 26th.
Can it be on 23rd or 24th? 23rd not possible. 24th okay, matlab.
This is item number 8.
Eight,
Huh?
eight.
Yes, yes, yes. Meter. 21.
Item 9.
May I please your lordship?
Oh.
The 483 application, my lord, accused is behind the bar 69 days.
Hmm.
It is a constitutional relationship was there. The Romeo and Juliet clause of Supreme Court judgment is applicable. And boy, girl is also 20 years, boy is 21 years.
So we'll issue notice.
Notice to respond what to.
Yes.
Gali,
Mr. S.C. Biswas.
Gali 20 years.
As per medical report.
So
He delivered a child also.
this is an application on the so the case relates to this relates to rape and pregnancy of the victim who was working, who was working in the house of this this house of this person, right?
Yes.
House of the accused applicant. Full stop. Let the notice be issued on respondent number 2. You write her through the registry as per the prevailing notification issued by the Gauhati High Court. Notice the respondent number 1 is dispensed with. Then you write registry to call for the TCR.
No.
is-
CD.
This
Not substitute, matlab.
Huh? Not
Actually,
subsidiary?
not subject.
Not subsidiary? Okay. Call for the case
CD.
diary. Call for the case diary. Let the matter be listed on
24, my lord.
24, how notice will serve, matlab, today is 16.
PP, brother.
It will not go through PP, it will registry has to issue, matlab,
So let the matter be
Second-
fixed on
2nd of March, matlab.
It's a long delay, my lord, because 69 days already behind the bar. Little earlier.
but no, see, Mr. The practical
Let it
thing,
go 26, my lord.
Mr. Biswas, practical thing is that no notice will not be served. Notice serving is a process that has to be served. I mean, without hearing them, we cannot hear them. Without hearing the respondent number 2, the court won't be able to hear the matter.
Then 2nd March.
It will, second must be giving.
Second March, I am-
Second must we are giving, we'll see. I mean, somebody appears, it's well and good. If somebody doesn't appear, then
Then you
again.
have to appoint.
Okay.
Daily hearing matter, Lordship. Already city was called for.
Huh?
Mankesar 157. 157. Matlab,
It's a motion matter.
yes, motion matter, matlab, it is fixed. Actually, we didn't get the file, matlab. Mankesar 157 CD is available along with item number 31. So at the time of 31 maybe, along with maybe taken. CD is available.
31 is bail hearing.
CD is available.
Okay.
Mankesar, it is not, that's not it. Item 13.
You can mention 10, 11, 12.
May I please, your lordship? So this is clearest bail application, lordship. And POCSO 6 is there, but one thing is, lordship, they are the husband and wife now, lordship. They have already got married and they are residing in the same house, lordship. And can you come to page number, lordship? 23 for a moment, lordship.
No, we'll issue notice. Then
deciding-
let the other side come, then
Thus
we'll.
this- for
That's
that,
it,
lordship.
let notice go from.
Yes,
Let the
lordship,
go.
that because husband and wife.
Heard Mr. That's good. I mean, let it come. I
Lordship.
mean, let the other side come and submit that dear husband, wife and all, then we'll consider. But
Lordship.
heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasa, learned AP for the state. This is an application so-and-so. The matter relates to rape of the rape of. This respondent of 2 is a mother.
No, Lordship, wife,
Respondent number 2 is
wife. Lordship, mother, sorry, Lordship, informant, sorry.
the
Mother.
informant's daughter was raped by the accused applicant. Let the notice be issued. So registry through so-and-so, respondent number 2, huh? As per Gauhati, notice to respondent 1 dispensed with. Call for the case diary. Let the matter be fixed on.
6th of March.
I'm sorry, Lordship, no.
It's a AB application, do little bit.
Sorry, Lordship, the respondent number 2 is not mother, Lordship, and he's the wife of the petitioner, Lordship.
She
I'm sorry, Lordship,
herself filed, na?
sorry, Lordship.
She herself filed it. And like the, after filing this, they married over.
Even initially, Lordship, and in the month of October, Lordship, he eloped, Lordship. At that time, Lordship, she was underage. That is why marriage was not took place. And subsequently, again, she eloped with the petitioner, and now he is at the age of 18, and they have got married, Lordship. They are enjoying their conjugal life.
Rape of the informant, stroke victim, huh? That rape of the. Okay, let her come, let her come. So, fix it a little bit earlier.
Lordship, and they are enjoying, Lordship.
Second, no, that enjoying is you're saying, no?
But
I mean,
no,
let,
so
that's.
Lordship, and kindly come to page number 20, Lordship, 26, Lordship.
Hmm.
She voluntarily sworn affidavit, Lordship, page number 26. And she is residing at husband and wife, Lordship, and so.
If it under what condition?
We'll consider this when
2nd of March.
let her appear, then we'll.
2nd of March.
Huh? 2nd of March, huh? 2nd of March.
If his wife or she will come.
26, Lordship, otherwise police disturbing, Lordship.
2nd is fine. 2nd, let her come and appear.
Lordship.
I mean, because husband and wife now notice is like, I mean, she is aware of this case is filed,
Yes.
is in file. Let her appear, then.
Let her appear.
Wait, no, without receiving the notice, she can come and appear.
Lordship,
Today also she could have appeared. Why not?
Section is, Lordship, and section.
No, today also she could have appeared. I mean, because husband and wife, I mean, she's also aware the case bail has been filed by the husband.
And POCSO 6 is there, Lordship. That is why, Lordship, police cannot grant, Lordship, at this.
Oh, I'm saying that she could have appeared
Why
here.
she has not
Lordship, appear.
The council could have appeared and stated the same things.
Obliged, Lordship, obliged.
Please, your Lordship. Lordship, the FIR is at page number 15.
Hmm.
The 15. Lordship, there is a delay of 4 days in filing the FIR without any reason. I mean, Lordship,
Is it not, it is not under POCSO?
no, Lordship.
Only
He is
this thing?
22 years old at that time.
Okay.
And the petitioner is the neighbor of the victim, alleged victim, your Lordship.
Yes, Mr. Parasar.
Some other allegations are also there, matlab, because
Huh?
of that, maybe some, for some other allegation, because some petty related.
Let him go. I mean, heard Mr. So-and-so, the learned counsel appearing for the accused applicant also.
Interim protection may
Uh,
be given.
I'm allowing this, then you are this thing saying. So-and-so, the learned counsel appearing for the accused applicant also heard Mr. K.K. Parasar, learned APP for the said. This is an application under so-and-so. The allegation as alleged in the FIR, inter alia is that the informant was the informant and the accused person are neighbors, and on 29/11/2025 at about 5 p.m. 5 p.m. the accused applicant took her to Gauhati. Gauhati is a place, Gauhati, to purchase a pair of sandal, and while returning home, he took her to a lonely place and tried to sexually harass her. Thereafter, the accused applicant um, took the informant to her house and tried again to sexually harass her. On submission of the FIR, the police registered Galaki, Zelakey, Galaki PS case number 41/2025 under the aforementioned sections, full stop. The learned counsel appearing for the accused applicant submits that the accused applicant did not harass the informant, and in fact, the FIR has been falsely filed due to certain misunderstandings. He submits that the accused applicant is a respectable citizen of the locality and without having any antecedents of any criminal offences. Full stop. He further submits that the accused applicant submits that the victim has in fact voluntarily went with him, and there was no intention on the part of the accused applicant to harass her sexually. Full stop. In view of the aforesaid, the learned counsel submits that the accused applicant should be granted pre-arrest bail at this stage. Full stop. But on the other hand, the learned APP opposed the bail, saying that there are serious allegations against the accused applicant. Full stop. This court has heard the submission made by the learned counsel appearing for the parties and is of the considered opinion that at this stage the accused applicant should be granted pre-arrest bail. Full stop. In view of the aforesaid, it is directed that in the event of the arrest of the accused applicant by the investigating authority in connection with Galaki, that right, Galaki PS case number 41/2025, the accused applicant shall be released on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order, that the accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating authority. Number 3, the accused applicant shall not try to tamper or hamper with the investigation in any manner whatsoever. Also, in view of with the aforesaid directions, the instant bail AB application is disposed of.
Right.
Disposed of.
Yes,
Allowed. Go.
highly obliged.
47.
Forty-seven.
Maybe call after 21, the lady will start. Start from 21. Yeah, let us start from 21. 21 of our bail start hobo. এটা কিন্তু supplementary.
Bail hearing,
21 of our
it is supplementary matter, no? It. Ke marise agote.
My lord, counsel is supposed to join in the BC lordship. He's
BC, anybody appearing? What? He hasn't joined.
after some time, Your Honor. Deeply appeal. 22.
The statement has come, the victim girl.
Yes, madam.
Last order was,
No, madam, evidence is not started, my lord. Only charges frame on 5/12/2025, madam. Otherwise, my lord, victim girl in her statement, she has implicated, my lord. He is the father, my lord, accused.
so no, none appeared.
Next week, madam.
None appeared when the matter was called for. Let the matter be listed on 25th.
Yeah, please, my lord. My lord, this is POCSO case. TCR received, and on the last occasion, my lord, amicus appointed, my lord.
Hmm?
TCR is received, POCSO case, my lord. TCR received, and on the last occasion, amicus appointed. my lord. In ES, Surojit Das. The Das is appearing, my lord. He was available, my lord. Do
So
not
we'll
know
take
where
up
he
after
has
some
gone.
time, we call him. If he's there.
34.
Yes, that is received.
None appeared when the matter was called for the accused applicant. Let the matter be fixed on 24th. Case there, so received to be retained.
25.
May please your lordship. Lordship, this is a regular bail application. Your lordship, office note indicates that service on R2 has not been completed yet.
But we have also inquired from the PS, my lord. We have not received the report, my lord, whether service is complete or not. But let the matter come up on Friday, my lord.
Okay. Office note dated 12/2/2026 reveals that service of a report on service of notice on respondent number 2 is yet to be received. Let the matter be fixed on
My lord, on 20, my lord.
on 20th.
Oblige your lordship.
27.
27 searches submitted, my lord.
What if in this case, lordship, it is session tribal, lordship, may I pray for escape,
Proceed.
lordship, out of love,
Proceed.
lordship, they look for getting married, lord. The victim was recovered from his house, lord, the accused person, lord.
So you go there,
It is session tribal, lord.
those be,
It will take time, lordship, the case has to commit, lordship, thereafter
Yes,
the bail will be done. May I pray, lordship, the only statement is required, lordship, victim statement.
Otherwise, Foxborough is not there, Lordship. She is more than 17 years.
More than 17, not below 18.
Below 18, but more than 17 years.
17 years.
More than 17 years. So 17 years, 2
Yeah,
months.
so below 18.
On their statement, Lordship, there whether any force or that has been applied or not, that. She willingly came with me, Lordship. We had a love relationship.
Can we maybe call for one?
Okay, heard Mr. S. Munir, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwa, learned APV for the state. This is an application you write, huh? This is an application you write. Mr. Munir submits that charge sheet in the instant case has already been filed, which has been confirmed by Mr. R.J. Borwa, learned APV. Scan copy of that TCR in the instant case. And then like something like this, registry to call for a scan copy of the TCR in the instant case. From which court?
There is not Disney law.
Disney which court?
It will be from Lordship SDGM M Disney.
SDGM M Disney. Let the matter be fixed on
27 months.
Not on 27. 26, Lordship. 26 or 25.
Okay, 25.
Lordship. Much obliged, your Lordship. Much.
Leg in another court.
No, it's gone now. Order is passed.
The petition is behind bar. and
No,
then
all the matters petition is behind the bars. You should keep somebody here.
My lord,
Order is passed. Next week. Next week. We have fixed 22nd or 23rd. Next week you come.
28.
Lordship, matter may be taken up after some time, Lordship. My senior will appear, Lordship.
Who is your senior?
It's Harish Lordship.
28, my scan copy was called for, my lord. Probably it is not received, my lord.
28.
28, my lord. On 4/2/2026, scan copy probably is my call for me.
Scan copy hasn't come, so we'll put it some other date,
Yes.
okay? There is no point waiting.
Lordship, short date may be given.
Has heard so and so. So and so. The office note dated 12/2/2026 reveals that the scan copy of the TCR has not been received. Registry to send a reminder for the scan copy of the TCR in the instant case. Let the matter be fixed on 24th.
My lord.
24th. 24th.
47.
Here in this case on Friday, this matter was listed and Lordship wanted to know what happened to the case which was listed in coordinate bench, Lordship, before coordinate bench. That order copy I have got, Lordship, he was granted bail considering the length of detention. I want similar. Yes, sir. In Sandan Das case, Lordship, granted bail in second application, Lordship. Initially, his case was rejected there. But in the present case, FIR, Lordship will find page 8, Lordship.
When was it filed? Case this thing?
My lord.
I mean, investigation not completed as yet.
No, the investigation is yet to complete, my lord.
So how many days now?
76 days as on today.
76 days on today.
And Somnan Das was granted bail considering detention of 73 days. Lord.
I mean, how these people are implicated? Got implicated?
Only allegation is that Lordship, some articles were recovered from their possession which suspect to be stolen property, Lordship. That forwarding report, page 15, your Lordship. will
There,
find-
there are some shop owners or something, somebody or not?
No, no. They were coming from a marriage ceremony, so after that, these things were recovered, allegedly recovered, Lordship.
Recovered
So
from
it is-
them?
Yes, it is yet to be proved that those are the stolen property, Lordship. So that they will prove, Lordship, during investigation, but whether further custodialization is only on that aspect.
As far as the materials are concerned, my lord, there are sufficient materials, my lord. The person, my lord, who has been granted bail, my lord, Sandan Das, my lord. He is the brother of the, my lord, complainant, my lord. Then he conspired with, my lord, one Sahidul, my lord. And then, my lord, they put some substance, my lord, in the food of the, my lord, complainant. Then when they become unconscious, my lord, then they came and, my lord, took away all the, my lord, ornaments and money, my lord. So as far as, my lord, Ashraf Ali and Nasimuddin, my lord, Nasiruddin, there are implications, my lord.
Where is the affair?
Page
FIR, I mean, phase,
8 is there.
phase, nobody is named or what?
Nobody is named.
Nobody is named. Heard Mr. A. Ahmed, the learned counsel appearing for the accused applicants. Also heard Mr. R.J. Borwa, the learned APP for the state. This is an application under so and so. One Sri Ajay Das. Ajay Shankar Das has lodged an FIR on 29/11/2025, alleging that on the night of 26/11/2025, when he went to sleep, some miscreants entered his house, breaking the backside door of his house. Then semicolon that after spraying some liquid materials on their faces, face, when the informant became unconscious, they broke his almirah and stolen gold ornaments amounting to rupees 24,000. Full stop. On receipt, on receipt of the FIR, the Avayapuri PS case number 265 of 2025 was registered full stop. On investigation, the police arrested the accused applicants along with some other people, full stop. Yeah, and since then for last how many days?
76.
Last 76 days, the accused applicants are in judicial custody. Mr. A. Ahmed, the learned counsel appearing for the accused applicant submits that the accused applicants have been arrested purely on the basis of suspicion, and it yet to be proved whether the ornaments recovered were actually the stolen ones or not. Full stop. He further submits that since the accused applicant has already spent 76 days in custody, further custodial detention may not be required in the instant case. Full stop. Instant case. He submits that two of the co-accused who had been arrested in connection with the instant case have already been granted bail by a coordinate bench of this court. Therefore, he submits that at this stage, the accused applicants should be also granted bail. Full stop. The learned APP, Mr. R.J. Borwa, on the other hand, submits that there are incriminating materials against the accused applicants in the case diary, though the charge sheet is yet to be filed.
Yet filed because, my lord, some stolen properties are yet to be recovered. my lord.
He further submits that some of the stolen property, stolen goods, stolen ornaments are
My lord.
yet to be recovered. Therefore, at this stage, the accused applicant should not be granted bail, full stop. Case diary is with you, no?
Yes, madam.
This court has perused the case diary as well as heard the submission made by the counsel appearing for the accused applicants, full stop. Taking into account of the fact that the accused applicants have already spent already spent 76 days behind the bars, and in similar situations, two of the co-accused persons have already been granted bail by a coordinate bench of this court. This court is of the considered opinion that further custodial detention in the instant case may not be required. Therefore, it is directed that accused applicants should be released forthwith on bail on submission of bail bond of rupees 50,000 each, with a surety of like nature, to the satisfaction of the
SDGM M not Shalmara.
huh?
SDGM M not Shalmara.
Sarmara, subject to the following conditions, that the accused applicants shall cooperate with the investigation. The accused applicants shall not try to temper or hamper. You write that. That's what that will do. In view of the aforesaid directions, the instant bail application is disposed of as allowed.
Right.
49.
May it please your lordship. Lordship, I seek some accommodation. Kindly the matter may be fixed at 2 o'clock.
We have received the case diary, madam.
Deeply obliged.
Mr. Bora is here?
Not here right now, at 2 o'clock, lordship. Deeply obliged.
Item 21.
Twenty?
21, madam, it was passed over for a timing, madam. That is why this call again.
Okay. We'll pass it off for time again. Who is the council pay item number?
21, madam. You board bhuya, madam. MU board bhuya.
He's on BC lordship.
Oh, he's on VC probably, yes.
Is it item 21?
Item
21. Item 21.
Yes. Mr. Agarwala, yes.
Yes, your lordship. I'm grateful for your lordship for allowing me to join VC minutes. It is regarding a Facebook comment. I was arrested on 12/11/2025. Subsequently, I was enlarged on interim bail minutes. Minutes may kindly peruse order dated 28/11.
What happened after the bail was granted to you?
After that, the charge sheet was filed and the TCR was called for minutes. The TCR perhaps is there at the court minutes. The FIR is at page 12, if I may, minutes. It's an innocuous statement, my lords, very vague. Before, if I may read, my lords, it's before every election we see there is a bomb blast like this, and after that there is a story, my lords. They've invoked all the other sections as below 5 years, my lords, but there's only sedition. Now, my lords, if for each statement to invoke any of these my lords, offenses, there has to be a violence, my lords. There has been no violence as far the my lords, the charge sheet, my lords. So may it be made the absolute minutes. I'll face trial.
What is his name?
Naseem Akram.
Naseem Akram.
Yes, Your Lordship. He's a teacher.
When was he arrested?
He was arrested on 12/11/2025. Subsequently, after 16 days, I was granted bail, my lords,
12/11.
to 2025.
2025, then allowed bail on
28/11/2025.
28/11.
This is a such case, my lord. Now lordship will have to consider this bail application on merit, my lord. Now, my lord, from the material, my lord, it is clear, my lord, that he tried to politicize the, my lord, bomb blast in Delhi, my lord. He has made a Facebook comment, my lord. My lord, that comment was like this, my lord. প্ৰতিটো ইলেকশ্যন আগত দেখোন এনেকে বোমা এটা ফাটাই ফাটাং পিছত আৰু বাকীখিনি কাহানী বনি যায়, my lord. This is his Facebook post, my lord. And my lord, this has been done, my lord, through his, my lord, Facebook account, my lord. And police has also seized, my lord, his mobile phone and, my lord, account details.
That
of the
Bima has
Facebook,
been
my lord.
given already.
My lord,
Mobile phone has been returned.
Ready to face trial, my lords. There is It's a complete, my lords, vague statement, if I may, my lords. There is one way of interpreting is that it's a political statement. The other way is also saying it that he is a citizen of India who is concerned with the way things are happening. And until unless there is any violence, my lords,
because, my lord, he has linked this mode of bomb blast with the election, my lord. That is why, my lord. He is trying to politicize the matter.
Let him face trial.
much
While
obliged.
D.K. Agarwal, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwal, learned APP for the state. This is an application under so and so. The only allegation against the petitioner is that he had made a social media post, media post in Facebook, as before every election we see there is a bomb blast like this, and after that, there is story. Full stop. The learned counsel appearing for the accused applicant submits that the statement is vague, and being a concerned citizen, he has made, being a citizen, he has made the statement without having any intention to bring in any enmity amongst the citizens of India. There is no intention of any mm, any uh, mm, any no, just keep it right like this. It says so and so. He submits that the accused applicant is ready to face the trial and abide by whatever conditions this court this court deems fit. Full stop. The learned APP, on the other hand, submits the charge sheet in the instant case has already been filed, and there are materials suggesting his intention of causing social disorder amongst the citizens, which is unwarranted. Full stop. Therefore, he opposes the bail at this stage. This court has gone through the trial court record that has been that has been produced before this court, as well as heard the submission of the respective counsel appearing for the parties. It is seen that the accused applicant was granted interim bail on 28/11/2025 2025 2025, whereafter the charge sheet was filed. Full stop. Taking into account the entire facts of the case, and since charge sheet has already been filed in the instant case, this court doesn't find any reason to cancel the bail, which has been already cancel the interim bail, which has been granted by a court in advance of this court. In view of the aforesaid, it is directed. And in view of the aforesaid directions, the interim bail so granted on 28/11/2025 is made absolute, and with the same terms and conditions as has been put by the court in advance in order dated 28/11/2025. In view of the aforesaid,
Grateful, Your Honor.
no other this thing is required. No? In view of the aforesaid, the instant bail application is
My
disposed.
submission and objection.
That I have written.
Grateful, Your Lordship.
From the 29 may be taken up at 2 p.m. Madam. We have to peruse the scan copy of the record.
Let it come Friday.
Friday. Madam.
Friday.
I have got other matter. Will it be inconvenient here for you? Friday?
Huh?
Inconvenient?
Friday. Okay, we'll take it up. Let them address this.
23 to Matiboni. Left over.
Item 23.
Yeah, please, Malad.
Yes.
In this case, Malad, petitioner were arrested on 13/2/2025.
13?
13/2/2025. Malad, charge sheeted case, Malad, all the witnesses are almost examined. Only, Malad,
How many witnesses were there?
total 7, Malad.
7.
Yes, Malad.
How many examined?
All examined, Malad. Only IO's further cross-examination is reserved, Malad.
As part of scan copy, Madam, PwC examined, Madam.
Huh?
As part of scan copy, Madam, PwC was last examined, Madam.
So only 7 is left.
7 is left, Madam.
7 is IO.
IO.
7 is IO.
IO.
So 6 out of 7 already examined.
IO also, in chief is over,
Hmm.
only for
First
further
examination.
examination is there.
Hmm.
My lord, FIR is at page 11, my lord. I'm mainly on the length of detention, my lord, and page 11 is the FIR. Allegation is of gang rape, my lord. Document perused is evidence of PW, my lord, victim guard, my lord, PW1, my lord. It is to do. It is to do.
Heard Mr. A.K. Gupta, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borua, the learned APP for the state. This is an application under so and so. Then you write an FIR was lodged by the informant on 13/2/2025, alleging that our minor daughter was kidnapped from mm, was kidnapped from a place near Ideal Nursery, Gauhati, and forcibly took her to Silchar by a truck by one allocation Sharma, and thereafter on reaching Silchar, the aforesaid Alokesh Sharma met the accused applicant, and thereafter they told the minor girl that they would be coming back to Guwahati through Diffu, full stop. While coming back, while on the way to Diffu, the accused applicant, along with the aforesaid Alokesh Sharma, raped the minor daughter of the accused, minor daughter of the informant, several times, full stop. it was also alleged that the victim girl was raped several times on the way to, several times before before they reached one petrol pump, wherein taking an excuse of going for urination, the victim girl fled away and contacted her parents through mobile phone of some unknown person. Also, on receipt of the FIR, the police lodged the Photosil Lambari PS case number 30/2025 under the aforementioned sections. Also, after investigation, the police filed charge sheet against the accused applicant along with the other co-accused person. Also, well-learned counsel. When was he? Okay. The accused person was arrested. In the same paragraph you read, the accused person was arrested on 13/2/2025, and since then he is in the judicial custody. Mr. A.K. Gupta, learned counsel appearing for the accused applicant, submits that in the instant matter, though trial, in the instant matter, trial has started, and 6 out of 7 witness PWs have already been examined, and therefore taking into account his long stay in the judicial custody, as well as the stays of the evidence, this court may allow the accused applicant to go on bail at these stays. Full stop. He submits that the accused applicant shall cooperate with the trial and appear before the trial court as and when required. Full stop. On the other hand, the learned APP, Mr. R.J. Borua, learned APP, submits that trial is going on a reasonable speed, and it is expected to be completed soon. Therefore, at this stage, there is no requirement of releasing the accused applicant from the judicial custody. Full stop. He further submits that trial court record aforesaid reveals the involvement of the accused applicant in the heinous crime. Mr. S. Das, the learned amicus curiae. You support his amicus curiae, submits that the allegation is of a heinous crime wherein a minor girl was alleged to have been raped several times, taking her to a different place from Gauhati. He supports the statement. He supports the submissions made by the learned APP. Full stop. The trial court record in the instant case has been produced before this court, and the same is produced. Full stop. After hearing the submission of the counsel appearing to the respective parties, and on perusal of the materials before this court is of the considered opinion that at this stage the accused applicant should not be released on bail. In view of the aforesaid, the instant bail application is rejected.
Malat, in this case, Sasit submitted long back, Malat, on 30th of December. He is behind the bar, Malat, 86 days, Malat, he has not approached or neither he has, might have not inquired because of that. Malat.
The charge sheet submitted
On 30th of December.
That means before 60 days.
Before 60 days.
Before 60 days.
On 22/11, he was forwarded.
So what do you want to do?
Let the TCR make call for Lordship.
You go there and appear.
Lordship,
You have not
POCSO 10
inquired
and 12,
anything.
malat, it will be malat released there, malat.
POCSO matter, you go there.
Lordship,
You go and
again,
appear there.
if I reject the same again there, then it may.
If I reject it here, it will be problem there. You will not get it. You will get another forum if it is rejected there.
Lordship, if possible, this I may call for Lordship.
No, unnecessarily, I mean, the certain council doesn't
Better for
understand.
you, because today the motion notice is not issued. You can approach tomorrow also before the court.
Anytime you can go there, it will take some time here. The calling for TCR, no, it's up to you. I mean, it's up to you.
Notice has to
But
be served.
I don't find any reason to keep it pending here. The POCSO matter also. What do you want to do?
Lordship, this I may call for Lordship because.
It's all for TCR.
Notice and TCR.
Heard Mrs. So-and-so, the learned counsel. But before coming to the court, I mean, you see, you are moving a bail application. It's not a simple petition you're moving, and you are not aware of anything what is happening.
Yes, Lordship.
Why is it so? Just you make a petition and come before this court without finding out what is happening, what is not happening. You are not aware of the facts properly. You are not aware of the status of the case. The charge sheet has been filed. You are not aware. Heard Mr. D. Bourbon, the learned counsel appearing for the accused applicant. Also heard Mr. P.K. Parasar, the learned APV for the state. This is an application. It will kill about this is an application. It will kill about this is an application under so and so so and so. This, the case relates to the case relates to filing of an FIR on 21/11/2025 by the informant alleging that his daughter of 12 years was sexually assaulted by the accused applicant. Full stop. It is submitted, that next part, it is submitted that charge sheet in the instant case has already been filed, also filed. Which court, before which court?
CS number 130/25.
White CS number so and so?
130/25 dated 30/12/25.
Where? In the court of SDCM?
Malat Kamalpur,
SDCM Rongia Award? No.
SDCM Rongia, it might be one.
Additional district and session just Rongia. Additional district and session just Rongia.
District and session just Rongia.
Additional district and
Additional district and session just Rongia. Full stop. Let the notice be issued on respondent number 2 through the registry as per the prevailing notification issued by the Gauhati High Court. Full stop. Notice to respondent number 1 is dispensed with as the learned APP enters his appearance. Full stop. Registry to call for the TCR in connection with this case from the additional session judge Rongia. Registry to call for scan copy of the trial court records from Rongia. Eta line kuchu, duta line no, eta line Rongia. Additional session Rongia. Let the matter fixed on 27th.
Deeply obliged, Lordship.
Item 31. Item 46.
Pass over the matter for time being.
Why?
Your
Why
Honor,
should
my
I pass
senior-
over?
My senior is in another
Who is
court.
your senior?
MA Islam, Lordship.
Huh?
MA
If
Islam.
he is not there, I will take up the matter. Sir. We have passed it over for earlier also we passed it to pass in. And if he is not there, then we'll take it up.
Next week, any day, Lordship.
On the prayer of the learned counsel appearing for the accused applicant, let the matter fixed in the next week.
46 may be taken, my lord, 46, my lord, along with this matter, it was motion, but BA. May be taken, my lord, series there.
46.
Yes.
Okay, we'll take it up in a second. 46. Then it will pass over. Am I so? Yeah.
31.
If he comes, then 2 o'clock. They tell him that
Yes, 31.
tell him that 2 o'clock afternoon I'll take.
Here in this case, I have been granted interim and thereafter lordship I appeared before the IO and my statement has been recorded. Lordship will find out FIR page 13, translated copy.
Khairuddin.
Yes.
Malat, regarding the malat interim of Khairuddin and next item Arif Ahmed. Arif Ahmed also interim granted. I have found the malat in the case the certified copy of order of Arif Ahmed, but Khairuddin malat malat I have not found malat.
But I have appeared also.
Malat no tools malat there. We have received the case study on 13/2. But
When did you appear?
On the, after receipt of the certified copy lordship on the next day.
Can you find it out, Mr.
but
Parasar?
Khairuddin,
Other person has appeared.
Yes.
Khairuddin has not appeared, but Arif Ahmed has appeared. Malat his certified copy of the order
Yeah.
along with bail bond, these are available. But regarding this item number 33, that is not available.
Can you find it out?
But I have found Malat, I have searched in the city, there is not there.
He's saying he is appeared.
Then Malat, another date may be fixed, we will update it at the city Malat. He is an interim. But regarding the other item, Malat, item number 35.
Arif Ahmed, he has appeared.
No. Yes, Arif Ahmed.
Arif Ahmed, there is no problem. He appeared as per the
Yes.
terms at least.
But
But materials there is different, but like he has appeared.
materials are
But in this matter, I mean, he hasn't appeared. It is liable to be cancelled, Mr. Dhar.
In the record, there is no certified copy of the order.
Malat, for this matter, item number 33, updated city may be called for, we will update it, Malat, if something is there, Malat, they will provide, whether appear or not, that note of the IO may be.
Okay, heard Mr. Ardhar, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, the learned APP for the state. By an order dated 27/1/2026, a coordinate bench of this court has granted interim protection to the accused applicant in the instant case. However, in the instant case, though the case diary in the instant case has been received no record of his appearance before the investigating officer as per the direction of the coordinate bench could be traced out. In view of the aforesaid, it is directed that an updated CD may be produced before this court on the next date fixed. Let
6th of March.
Let the matter be fixed on
6th of March.
6th of March. You need to, before that,
AB Malat, interim,
I mean,
interim Malat, no issue Malat.
they don't have any issues. Okay, 6th of March.
interim order will continue.
Interim order so passed earlier shall continue. But if you are not appearing, then
I appeared, lordship, but
then the fun and joy and maritime you are having, then that you'll have to spend behind.
Lordship. In item number 34, I appeared, lordship, interim order made absolute lordship.
But regarding item 35 and the.
I am appearing.
Hmm?
35 regarding item.
34 Arif Ahmed. Against him, Malat, materials are there because Malat, the victim lady Malat informant, she Malat, in her statement, Arif Ahmed, Iftikhar Hazarika, Muk.
It is, I mean, from the same FIR, right?
Same
FIR.
FIR, same FIR. But in her statement, matlab, right.
Hey, Mr. Parasar, let him go. I mean, he is appearing. I mean, what is to be done? I mean, I have gone through this. Heard Mr. Ardhar, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. This is an application under you, right? Huh? This is this. The brief case, the brief of the case is the gist of the case is that the complainant lodged an FIR stating that on 12/1/2026 at about 6 p.m. when she was reversing her vehicle at a road near Tezpur Market, the vehicle was hit by a motorcycle of accused number. Iftikhar Hazarika is who? Your father?
Iftikhar is item number 35 and
Item number 35.
another item 36 was also there, that was withdrawn, same name.
35 is different again.
Yes.
Iftikhar Hazarika, full stop. The complainant then left her vehicle to ask the accused, the aforesaid accused, aforesaid Iftikhar Hazarika, whereon whereon the aforesaid person started shouting at the complainant using obscene language and forcibly touched her private parts. The complainant's husband and father-in-law came to rescue her when the accused number 1, along with accused number 2, Joyson Hazarika, and several others came and with the intent to kill, physically assaulted the complainant's husband and father-in-law, causing grievous injuries to them. While leaving, the accused persons threatened them, saying, "Hindu dominance won't work." First, after receipt of the FIR, the accused, after receipt of the FIR, the police registered Tezpur PS case number 035/2025 under the aforementioned sections. Full stop. The coordinate bench of this court, by its order dated 27/1/2026, interim bail, full stop. It is submitted by the learned APP that the accused applicant has already appeared before the IO and got his statements recorded.
The statement I have not found, matlab he has appeared, he bail bond
Okay,
already,
he
the
has
statement is not.
appeared before the IO, full stop. Next para. The learned counsel appearing for the accused applicant submits that he has already appeared before the IO and shall cooperate fully with the investigation. Therefore, he may be allowed. Therefore, his interim bail should be made absolute. Full stop. Taking into account the entire facts of the case as well as the accused applicant's appearance before the IO, this court is of the considered opinion that the interim order interim order dated 27/1/2026 should be made absolute. Accordingly, the same is made absolute in the same terms and order, same terms and conditions as stated therein. In view of the aforesaid, the instant AV application is disposed of. 34 is disposed of, 33 will be updated, 35 also same.
35 also same, 35 and 36, this is Iftikhar, he has, that motorcycle belongs to him, Iftikhar. Now one item, today morning withdrawn, by Learned Counsel Thor, that is 36. Same person, 35, and subsequently file item 36. It
Yeah,
was
we'll take up
AB
with you.
146 and AB 312.
So we'll come back after 5 minutes. Just connect from it.
Interim দিয়া কাৰণে on the first day, interim was not granted because that motorcycle belongs to him, that scooty, and allegations against him in the affair. Subsequently, on the, he filed another
After not getting interim, he has filed another.
case. That is 36.
That has been withdrawn.
Withdrawn,
Oh.
That should
is his
be the
conduct.
conduct of that petitioner, when one case is pending and he filed another case, and the lady, while the lady parking the vehicle, slightly hit the scooty, and two persons, Arif granted that Arif and Iftikhar, both assaulted the lady. Subsequently, she called her husband. Husband also assaulted.
The conduct is not good.
Not good. Conduct is not good.
And along with when the lady called her husband, this Iftikhar also called his father and all this. Joshon, 2-3 person, other person came. That one person also arrested also subsequently. That father of this petitioner.
What happened to him? What happened to him?
He was subsequently arrested. In the case, I have found 36 notice.
But already Arif has been granted bail, so let him go. Heard Mr. A. Khanikar, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, the learned APP for the state. This is an application under so and so. The briefcase the same. No. The item number 30?
34.
34. The learned Mr. A. Khanikar, the learned counsel appearing for the accused applicant submits that the case arose due to certain misunderstanding in the heated moment, and there was no intention or motive to harm anybody in the instant case. Full stop. He further submits that a co-accused in the instant case has already been granted bail granted anticipatory bail by this court. He further submits that the accused applicant shall cooperate with the investigation and abide by whatever conditions this court may put in the case of his release or in case of he being granted anticipatory bail. Full stop. The learned Mr. K.K. Parasar, the learned APP, on the other hand, submits that the conduct of the accused applicant is not good, as he had filed that during the pendency of the instant bail AB application, he has filed another AB application, which was subsequently withdrawn. Full stop. He further submits that there are materials against the accused applicant's involvement in the alleged offense in the FIR. Full stop. In view of the aforesaid, he opposes the bail AB application at this stage. Taking into account the whole facts of the case, as well as after perusal of the case diary, this court is of the perusal of the case diary. This court is of the opinion, considered opinion, that the accused applicant should be granted the privilege of anticipatory bail at this stage. Accordingly, it is directed that in the event of the arrest of the accused applicant, by the investigating authority in connection with Tezpur PS case number 035/2025. He shall be released on bail on furnishing of a bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. The accused applicant shall appear before the investigating authority within 7 days of passing of this order. The accused applicant shall cooperate with the investigation and shall appear before the investigating officer as and when called for. Then third, you read, the accused applicant shall not try to influence any of the evidence in whatsoever manner connected to the incident case. Full stop. In view of the aforesaid directions, the instant AV application is disposed of as allowed.
Minus, can it be taken off some for the time being, my lord? You can-
How many times the time being you want?
51, my lord.
Hmm?
51, my lord.
Who is arguing this matter?
Mr. A. Ahmed was arguing this.
Huh?
Mr. A. Ahmed was arguing this case, my lord. Next in
Okay,
51.
time being.
It will be.
Item 16 admission.
Bail नहीं करो. Okay, bail नहीं करो.
May I please
Mr.
your lordship?
HR Chaudhary, I said I got to try to code up any time being it as well.
May I please your
Mr. HR, Mr. Chaudhary, you have which matter?
46.
Or 6 can be taken up now? Bail hearing?
Well,
Let us take it, I mean, before taking the admissions. How about it? Since he is here, we'll take it up.
46 and 31.
31.
That council.
Have you informed that other council?
You inform other council. In the meantime, my lord, Learned Senior can argue.
Okay, you inform him, I told you to inform him.
31. MA Islam. Jay Mondal.
He was here only. He's-
Yes, sir.
huh? Or else we'll take after some time. I mean, you called him, you know him, that the council. He was here only, and I told you that you intimate him that matter will be taken up.
Learned Senior can argue, my lord.
No, other matter.
My lord, Learned Senior's matter is for BA.
Ah.
That Learned Senior can start, my lord.
No,
Another AB.
Okay. Okay.
This case, but my only question, my lord, here I am not coming 47, 48, my lord.
Hmm?
On merit, my lord, contents of the seized materials. Your
Okay.
lordship kindly see page 10. And page 11, the next page, my lord, your lordship will find paragraph in the midtime seized items.
Yes.
20 bottles of codeine phosphate so and so, weight 2,659 grams. Now this with bottle, my lord. Now contents, it will be, if it is 100 ml, it will be 370 some grams, my lord, it comes, my lord. On only FSL, I don't know, my lord, whether FSL has come or not, my lord. I'm only on that, my lord. I'm not, it doesn't come under commercial quantity, my lord, if at all.
What is the commercial quantity here?
No, my lord.
One kg.
Codeine,
1 kg.
Codeine, my lord, 1 kg. My
1
lord,
kg.
20 bottles of 100 ml. 20 bottles of 100 ml, my lord, is equivalent to around 2000 ml. 2000 ml is equivalent to around 22 kg.
No, 20, not 2000 ml.
20 bottles
20 bottles.
of 100 ml each.
Hmm.
Is 20 bottles of 100 ml is 2000 ml.
Hmm.
Then it will equivalent to, my lord,
2 kg.
2 kg.
Hmm.
Now, along with the bottles, my lord,
Hmm.
along with the plastic bottles, 2,688, 2,689
59.
59 gram, my lord, they have, my lord.
Hmm.
Along with the plastic bottles.
But
So
any,
it will, above one kg.
is there, I mean, whether you have weighted it?
Now, weight is there, but not separately. Along with the bottles, photograph is also there, but all 100 ml bottles.
No, what is the law? And while waiting, you are not supposed to wait with the
Weight
bottles.
separate weight.
Mm.
But prima facie, it is above 1 kg. 1 kg is the commercial.
Tell us exactly what is the as per your the cost.
Along with bottles, they have mentioned 2,600 this but 100 ml bottles 20 bottles prima facie in the as per seizure also 20 bottles. 20 bottles.
100 ml lagi. So, you have to 100 ml to buy him. FIR. Okay,
So it will, Mr. Chaudhary, otherwise also it will be more than 1 kg. And there is no doubt about this.
But let them say, my lord. But I am only let it come if necessary, my lord. Let them say.
Because 20 bottles, usually these bottles are 100 ml. Usually.
100 ml.
100 ml.
Usually.
In the inventory order, Lanet Court has mentioned now I have allowed drawing of 2 bottles marked as 100 ml each as sample codel. They have 2 bottles sample where as 100 ml each sample. So 2 bottles were sent for sample out of this 20.
Human, I said 2 bottles. I think
It's 2 bottles in a sample each 100 ml. So 2 bottles if
it will be more than 1 kg.
More than 1 kg, around 2 kg. Otherwise, and from the statement of this accused person, he is repeatedly doing this. His statement also, from he stated that I am doing this since long, and when he went to sell this 20 bottles to a person, police kept along his
basically, paragraph 5 is my case, madam. So he stopped his vehicle in presence of a vegetable shop. Madam. This is all. Now, rest is subject to lordship whether your lordship believe or not. Paragraph 5, page 4. This case, madam.
At this age, it will be difficult to believe Mr. Chaudhary.
Yes, that I agree with that.
Heard Mr. H.R. Chaudhary, the learned senior counsel, assisted by so-and-so counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. This is an application under so-and-so. The case on 23/11/2025, one SI, Rustom Ali Ahmed of Mankachar Police Station lodged an FIR before the officer in charge Mankachar Police Station, alleging that on 22/11/2025 at 8:41 p.m. on receipt of a secret information, police while doing Naka checking at Mankachar Tiniali at about 8:50 p.m., the police found the accused applicant coming from Mir Zumla side towards Mankasar town on a bike bearing registration number AS 347726, semicolon, that during the body charge and inspection of the bike, they recovered a pink colored bag containing 20 bottles of codeine phosphate and tripolidine hydrochloride syrup, full stop. The police seized the materials and arrested the accused applicant, full stop. On receipt of the FIR, Mankachar Police Station case number 157/2025 under section 21 in bracket C stroke 29 of NDPS Act was registered against the accused applicant. Because the learned senior counsel appearing for the accused applicant fairly submits that he wants to, submits that though the bottles, bottles, though 20 bottles have been recovered, the contents of the material inside the bottle were not separately weighted. Therefore, it cannot be, therefore, it cannot be, cannot be termed that the narcotics, that the contraband material seized would be more than commercial quantity, more than commercial quantity. He submits that the police authority should have measured the contents separately after taking out, after keeping the bottles aside. In view of the aforesaid, he submits that this being a procedural lapse, the instant bail application should be allowed. Mr. K.K. Parasad, a learned APP, on the other hand, submits that from the materials, from the case diary, it is seen that the bottles, that each bottle contained 100 ml of contraband material, which goes to show that 20 bottles would be definitely more than 1 kg, comma, that is the benchmark under the NDPS Act. Therefore, he submits that there is no merit in the instant bail application, and therefore the same is required to be rejected. Full stop. This court has gone through the case diary that has been produced before this court, as well as heard the submission made by the counsel appearing for the respective parties. It is clear that it is not disputed that 20 bottles have been recovered from the accused, from the possession of the accused applicant, and if the bottles are taken separately also, if the bottles are weighted separately also, the contents will definitely be more than 1 kg, 1 kg benchmark, in view of 1 kg benchmark. Therefore, the quantity being taken to be more than 1 kg, which is a commercial quantity, at this stage, the accused applicant cannot be granted bail. In view of the aforesaid finding, in view of the aforesaid prima facie finding, this court doesn't find any merit in the instant bail application, and the same is rejected.
That counsel is out, he went to CJ, perhaps he thinking that it will take at 2.
Okay, we'll take it up after some time.
Maybe at 2.
Pending item 21. Sorry, Lordship, I was not there when matter was.
Yes.
This matter, your Lordship, heard on Friday, Lordship, that I submitted that except co-accused statement, there is nothing in the record to connect the present petitioner with the crime. So my learned friend took time to verify whether any other material is there or not, except the co-accused statement.
Well, I have verified from the scan copy of the record, my lord. My lord, in the Caesar witnesses, my lord, they have not implicated. They have only implicated the main accused from whose possession, my lord, the contraband was recovered and seized, my lord. Now only, my lord, the accused person, my lord, he has stated, my lord, that he supplied the contraband, my lord, with a view to, my lord, to deliver to two ladies, my lord, in, my lord, in Nilam Bazar, my lord. That is the statement of the, my lord,
And this applicant is one of those person who was supposed to have received it.
No, my lord. Applicant is the person, my lord, who has handed over the contraband to the arrested accused person, my lord. And there are also, my lord, some call details, my lord, CDR analysis. But from there, my lord, I could not, my lord, verify, my lord, whether, my lord, any call details between the accused person and the, my lord, this accused person and the, my lord, person from whose position the, my lord, contraband was recovered, my lord. Because in the search sheet, my lord, there is no such mention, my lord.
About CDR, there is no mention in the charge sheet. And in the initial documents which I have placed before your Lordship, FIR, forwarding report, and the notice under section 47, nowhere disclosed that the co-accused initially revealed the name of the present petitioner. That he simply says that he was supposed to deliver to other unknown women.
Question is that,
And
madam, these are,
except that confessional statement, no other connecting material is there.
question is that, madam, these are organized crime, my lord. So, madam, it is also, my lord, it is also not easy, my lord, to, my lord, to connect the, all the accused person along with the main accused person, my lord.
I mean, you were in interim mode? No.
In the charge sheet, madam, he has been shown absconder, my lord.
Thereby also the arrested person is granted regular bail, and if he appears, lordship, the trial will proceed.
These cases are for what?
That in similar situation, they were protected, lordship, because also only co-accused statement was there, and apart from that, no material was there.
So CDR, was there any call, direct call?
So that I cannot verify, my lord. So we kindly see there, my lord, CDR, my lord. We cannot, my lord, we not been able to, my lord, possible for me to understand, my lord. But there has to be something, my lord, in the search sheet, my lord, that there are some CDR call, my lord, that is, that has been done between the accused and the, my lord, the other accused person, my lord.
But otherwise, there is no allegations, there is nothing.
Except, my lord, my lord, the.
No,
apprehended
no,
accused person,
from the statement of the other, I mean, the investigating officers also,
my lord.
whatever they have made, they have not implicated him saying that there was a call, there was something, nothing. Heard Mr. A. Ahmed, the learned counsel, preparing for the accused applicant. Also heard Mr. R.J. Burwa, the learned APP for the state. This is an application under so and so, so and so. An FIR was lodged on 16/7/2025, which alleged that on receipt of certain secret information, the FIR lodged on 17, not 16, 17. No, 16. 2 dates. FIR is 16 or 17?
18,
Huh?
15/7, page 15.
Why you have written 16 FIR with it?
A GD entry was lodged that
No,
17.
a copy of FIR you have written 16/7.
I'm sorry, Lordship, in the body of the petition was.
18/7, 18/7. An FIR was lodged on 18/7/2025 by one SI in bracket P Somar Burman of Nilambajar Police Station, alleging that on receipt of an information that one motorcycle bearing number NL-J7917, which was ridden by one person, namely Abul Azad, was suspected to be transporting huge quantity of narcotics contraband from Nilam Bazar side to Sri Bhumi. Accordingly, the informant placed Naka checking, and at about 7:20 p.m., the said motorcycle was detained and the person was apprehended. See, Mr. Ahmed, when you write the details of the FIR, you should disclose all the things and put in sufficient details. So that I mean court comes to know about like what is there in the FIR. Usually the FIRs are pretty lengthy, and if you do not give the details properly, then it becomes difficult for the court, and it doesn't look good. I mean, you don't give the proper details, whether a contraband material was seized or not. There is no, I mean, nothing has been stated in the paragraph 3. Huh?
I'm sorry, paragraph 3 I've seen.
You should write that one detained, this much of materials were seized, then he was arrested. All these details should be disclosed.
I'm sorry.
If you do not disclose all these things, I mean, it's not possible to go through the whole, this thing. The court expects that like certain things will be disclosed which are true and which has been put in from the FIR. So that like, and all details of the FIR and all these things need not be seen by the court. Huh? But there is nothing, I mean, you have written here. How much quantity was this thing?
3000, Lordship, 30,000.
Hmm?
30000, Lordship.
3,000,
Or
30,000.
30,000.
See, otherwise also like if you do not write all these things here, do you think like, I mean, the court without looking into it, I mean, the bail will be granted to you?
This is my mistake, Lordship.
Hmm?
I'm sorry.
And you have not stated anywhere how many tablets were disclosed. I mean, you people may be thinking that, okay, court will see 30,000 and like they'll got, they will immediately get biased or something like, it's not like that.
That is.
So 30,000, at least 30,000 Yaba tablets were recovered from the possession of the accused applicant. On receipt of the FIR, the aforesaid, special NDPS case number 65 of 2025 under the aforementioned sanction was registered. After investigation, the police filed the charge sheet by charge sheet number 131/2025 dated 3/12/2025 against the aforesaid Azad, against the aforesaid Abdul Azad, aforesaid Abdul Azad, as well as against the accused person. Namely Babul Hussain alias Babul full stop. The learned counsel, Mr. A. Ahmed, the learned counsel, appearing for the accused applicant, submits that the accused applicant has been named in the charge sheet only on the basis of suspicion and on the basis of a confessional statement that has been made by the main accused before the police. He submits that it's a settled law, and that the law has been settled by the Honorable Supreme Court in catena of cases that a person that on the basis of a confessional statement, a person cannot be termed as an accused without having any materials linking the accused applicant, the accused person to the offense. Full stop. In connection, in this connection, he has referred to the case of Tufan Singh versus State of Tamil Nadu, reported in 20214 SCC 1, as well as the case of Sanjeev Chandra in bracket criminal appeal number 1273/2021, decided by the Honorable Apex Court. He submits that in support on the basis of the aforesaid case laws, he submits that the Honorable Apex Court has ruled out the use of confessional statement against another person. Full stop. He states that he submits that in the instant case also, other than the confessional statement, there is no incriminating material connecting the accused applicant to the offense so alleged in the FIR. Therefore, on this ground alone, he should be granted bail. Full stop. The case diary in the instant case has been produced before this court. It's a TCR, eh? TCR. The trial court record, the TCR in the instant case has been produced before this court, full stop. The learned APP, Mr. R.J. Bowa, the learned APP, learned APP submits that there are numerous submits that the main accused applicant, that is Abdul Azad, has specifically stated before the police that the seized contraband was in fact delivered to the accused applicant by the aforesaid Abdul Azad. He submits that at this stage there is a clear link of the accused applicant with the main accused in the instant case. He further submits that he further submits that the mobile phone and CDR records have been received, but at this stage it cannot be made out whether there are materials in the CDR which directly or indirectly implicates the accused applicant.
Another
In view of the aforesaid, yes.
Another submission case has also been registered under section 29
Hmm.
of the NDPS Act.
Hmm.
So there is a conspiracy part that has to be proved during trial.
He further submits that since the case has been filed, since a charge has been since the charge sheet has been filed under section 929 of the NDPS, the conspiracy between the accused applicant and the main accused in the instant case cannot be ruled out.
My lord.
In view of the aforesaid, he submits that at this stage, this court should not allow the accused applicant to go on bail, as he has been already declared as an absconder in the charge sheet filed by the police. But absconder, how the police?
Police has not declared him absconder. Police has shown him absconder in the certain manner. Declaration will be made by the court.
Correct. I mean, but whether you can write like that, I mean.
Shown, my lord, absconder.
Okay, police, he has been shown, not declared, he has been shown as absconder in the charge sheet.
My lord.
But what about these cases, I mean, Supreme Court cases, what will you do with this? What is your submission on that?
Well, regarding Tufan Singh, my lord, what my learned friend has submitted, my lord.
Yeah, Tufan Singh, see, I'll read out what Supreme Court has said.
My lord.
Supreme Court has directly stated the appellant has been arraigned as an accused on the basis of the co-accused statement.
My lord.
As to actual complicity of the appellant is an issue which will have to be thrashed out after the trial. And such appellant would be entitled to being released on bail.
My lord. Well, initially, my lord, in Tufan Singh, my lord, Supreme Court.
No, Tufan Singh can be, Tufan Singh is a ratio which has been followed by all the courts. But only thing exception is that if you can directly link conspiracy theory can be really brought in, then you can say that Tufan Singh has a different facts. But in this case now, I mean, other than the co-accused statement, you don't have anything. And Supreme Court has specifically stated that on the basis of the statement of the co-accused, you cannot detain him. I mean, that can be thrashed out during the trial. That is what.
But there, actually, my lord, ultimate, my lord, the find out of the Supreme thing is that, my lord, not only basis of the co-accused statement, my lord, a person cannot be convicted, my lord. There has to be something more, my lord. That, my lord, suppose, my lord, there are some.
That will be seen in that trial court. That is what it has been stated here.
Yes, my lord. Only,
now, in this case, the Supreme Court has said so.
Yes, only on the basis of co-accused statement, my lord, person cannot be convicted.
Correct. Now,
there is no other material, my lord. That is what Tufan Singh has told, my lord.
Now thing is that in the bail stage, now it is stated that only if there are no material to connect, positively connect these two people, then in that event, in the stage of bail, I mean, only on the basis of this thing, he cannot be detained.
No, madam. Now, my lord, my learned friend's submission is that, my lord, he wants to appear before the trial court to face the trial, my lord. To that extent, my lord, I leave it to your lordship, my lord, to that extent, my lord.
No, that
if
is
there
what,
are-
that is what, that is nothing
Yes,
else.
my lord. But if materials, my lord, that will be proved during the trial, my lord.
Definitely, that has been stated. That's what I read out, that it will be thrashed out during the trial.
Yes, my lord.
So if there is something there, I mean, there is nothing can stop, I mean, stop the, the prosecution to bring him on board if there are materials. That cannot be stopped. During the trial, also a lot of materials can be brought. But at this stage, I mean, that this is clear. So that is the problem. Problem means that that is the way it has to be done, because
Yes,
at
my
this
lord, it
stage, you don't have
becomes
anything.
difficult, my lord, to bring, my lord, direct evidence, my lord. With the, my lord,
That
with
that
the
is
quick
there,
going
Mr.
up.
Borua. I mean, now what is to be done? This court has heard the submissions made by the counsel appearing for the respective parties, as well as perused the trial court records produced before this court. Taking into account the ratios laid down by the Honorable Supreme Court in the case of Tufan Singh, then case of Tufan Singh Supra, Sanjeev Chandra Agarwal Supra, Supra, as well as the case of Rambali Sahni, versus State of Bihar, in bracket, criminal appeal number 105 of 2026. You write all these things, huh? From here, this one, just mark it. This court is of the, this court has taking into consequence of, this court is of the opinion that 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 in the trial court record, in the TCR, which has been produced before this court, there is prima facie no such material which implicates the direct, which suggests the direct link of the accused applicant to the offense that has been alleged in the FIR. The CDR of the mobile phone of the accused applicant also prima facie does not indicate any active link of the accused applicant with the main accused, that is that is Abdul Azad. Full stop. Full stop. Full stop. Comma. Again. Comma. This court is of the considered view that the accused applicant should be given the privilege of pre-arrest bail at this stage with certain conditions. For certain conditions, full stop. In view of the aforesaid, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with special NDPS case number 65/2025, the same, the person, the accused applicant shall be released on furnishing of a bail bond of rupees 1 lakh with 2 sureties, one of which has to be a government servant to the satisfaction. Now we are to the satisfaction of the special to the
Special
satisfaction of
judge?
the learned to the satisfaction of the special judge NDPS Sirvumi, subject to the following conditions. That the accused applicant shall appear before the learned special judge. The special judge, NDPS, NDPS Sirvumi, within a period of 10 days of passing of this order. Secondly, the accused applicant shall appear before the shall participate in the trial relating to the case and be present before the trial court as and when required. Full stop. The accused applicant shall surrender the copies of his PAN card, Aadhaar card, driving license, and the passport, if any. Then you write the accused applicant shall not leave the jurisdiction of the special NDPS, jurisdiction of the special court, POCSO, Sirvumi, without prior permission of the aforesaid court.
Special judge.
In the event of permission granted to leave the jurisdiction of the special court, he shall leave his details. He shall leave the details of his address with the special court. Full stop. The accused applicant shall not try to that conditioning with evidence. In view of the aforesaid directions, the instant AB application is disposed of.
The jurisdiction of special judge NDPS, your lordship has said POCSO.
Oh, sorry, NDPS. I have restricted NDPS only
No,
in some places. Maybe it has gone like.
I pray for one more line.
Yes.
These observations made in this order, my lord,
Hmm.
only for the purpose of, my lord, disposing of the bail application.
That observation of what?
No, whatever the lordship has made some observation. my
No,
lord.
we have made only observation only on the basis of Supreme Court cases, nothing else. No independent observation from this
My
court.
lord,
We have only stated that prima facie could not find anything.
I'm obliged.
That we can put it, I mean, we'll put it, not a problem.
Problem. Your initial complaint, your lordship will find at page 11, lordship. He was arrested on 25/12/2025. As on today, 54 days in custody, lordship, and mandatory period is 60 days, lordship.
25 to 1.
25/12/2025.
Now, how many days spent?
54 days as on today, lordship.
What is this additional affidavit or whatever?
They have filed their objection, lordship, in this.
Objection.
1 kg, 463 gram of dried weed was recovered.
1 kg
463 grams.
of
And, it is weed, lordship,
cannabis.
lordship. And a small quantity is 1 kg and commercial is 20 kg. Just above small quantity, lordship. In my paragraph 5, I have stated the grounds, lordship, that his travel agent gave that packet to deliver it to his family members. Accordingly, he brought it. And knowingly, probably he will not carry those articles, lordship, in airport, lordship. And already 54 days in custody, lordship, mandatory 60 days. Lordship. That length of detention and that part lordship not considered.
Yes.
May I please, Lordship, due to some personal difficulty, Mr. Kel is left the court, Lordship. If Lordship grant permission, may I submit, Lordship?
Yes.
Lordship, contraband recovered from his position, Lordship. Is his value is very high, Lordship. 1 crore 46 lakhs 30,000, Lordship.
But you haven't filed charge sheet till now.
1 week left, Lordship. See.
You want to wait or what?
We have CD,
Consider
Lordship.
the detention period, lordship. Already everything is see, lordship. And if your lordship see his statement, that your lordship will have next lordship that also shows.
Investigation is earlier stage, Lordship.
After 54 days also you say earlier stage. Investigation to do. difficult, Mr. At this stage, it will be difficult.
4 days, Lordship may fix this on Thursday, Lord. Thursday or Friday, Lord.
We'll fix it some other day.
Lordship.
Lord Mr. A. Ahmed, the learned counsel appearing for his applicant, also heard Jan Kotoki, learned counsel appearing for the special counsel, this,
DRI Lordship.
yeah, customs, for SC, on the prayer of Mr. A. Ahmed, the learned counsel appearing for the accused applicant, let the matter be fixed on 54.
Friday or Thursday, Lord.
19th. 19th will file. We'll fix on 19th.
Problem. May I please, Lord? 49, my lord, I am on interim. The honor has granted interim bail, my lord, on the last occasion. And the case diary was called for.
Yes.
My lord, today, on behalf of informant, I have filed a wakalatnama, my lord. So kindly 2 days time may be permitted.
No, you tell whatever is there, why, I mean,
I
matter
don't
was.
have the petition copy as well, my lord.
Hmm?
I don't have the petition copy,
He'll give you.
my lord. Because it's quite voluminous. If 2 days time may be permitted, my lord.
Yes, Mr. Borua. He give me a copy, Mr. A. Informant.
Definitely.
If you have a copy, extra copy you have. What are these transactions?
Transaction, after the alleged incident, I have used to pay her and she is also paying me regularly, my lord. That it shows that both are in good terms after the alleged incident also. In the last date of the filing of the FIR also, she has paid me 30,000 rupees, 22,000 rupees from her own account to my account. And before that, on 17th January. And I have next one later also written by her. That later also, my lord, page 56, my lord, in the October.
Mr. Your name?
Anand, ma'am.
Anand. Anand? And Anand. See, like all these are transactions, all volumes of transactions. So ultimately, the material thing will be not, so you can go through it.
Only that much, my lord. These are only bank transaction.
No, these are only transactions, they say, nothing else.
Transactions from my side, my lord, the thing is that he had been paying me, which I returned. He had been voluntarily paying me, which I never asked for, and I returned. These transactions are showing that only.
Why voluntarily paid?
That, with that person, the petitioner was paying.
No, why?
For what reason, I don't know. I never asked, and I used to return that.
But this is very surprising. Somebody pays you voluntarily money.
Preparing for the UPSC, I'm a student and I'm preparing for the UPSC exam.
Okay, Mr. Borua, what is there?
Yes, my lord. Lord, so kindly produce the case diary, my lord.
Yes, yes.
183 statement, my lord. He is implicated, my lord.
Hmm.
And my lord, the incident occurred from last year to February 2025, my lord. Initially, I'm just, my lord, pressing the materials, my lord. Initially, my lord, there were introduction, my lord. Then, my lord, they have started.
I mean, there is no doubt that they had some kind of affair, right?
Affair, my lord.
Affair, right? And affair, I mean, like now love story went sour.
My lord.
It went sour. So like, I mean, love story went sour, then One,
In between them, my lord, he married her, my lord, once initially, my lord, as per Hindu, my lord, rituals, my lord. Then, my lord, as per my lord, Mohammedan rituals, my lord.
mm.
And in between that, my lord, till filing of the my lord, FIR, my lord, she was assaulted several occasions, my lord. That is why, my lord, I like to.
But a
tell-
marriage is there any documentary proof of marriage?
My lord, that is not yet because
there-
investigation is
Fire
very.
itself, she has admitted that initially I married her by following the Hindu rituals. And secondly, again, I have followed the Muslim rituals. So it shows, my lord, that both are in the relationship and both are adult. And there is a transaction going on, and she herself in her letter written to me, my lord, admittedly she is said that I am just like your wife. She has accepted, that is, my lord, page 60, page 59, the translation part. I am also annexed the translation 55 last lordship, page 55, last line. Last few lines, lordship, kindly see. This letter dated, my lord, 27/10/2025. Last 3 lines.
Yes,
How she is
27 to 2025, and like this FIR was lodged on
18th of January 26. And the alleged incident happened February 25. After the incident also,
Mhm.
she has written this letter, and whatever the assault taken place,
Where page?
page 52, my lord, type
52.
copy,
Hmm.
and the original copy your lordship will find 56.
That's it.
And the
Last three lines I have seen that.
Yes.
As assault also she has written here.
No, nothing, my lord. No assault, not a whisper. Rather, she has accepted herself to be my wife.
It's a Mr. Anand. I mean, would you like to go through it a bit? I mean, I can give you some time if you want. Some not the whole. I mean, like I'll take it up after some time. I may give him some time. I mean, if he wants.
I do not have much of the information either from the informant side, my lord. That's
Hmm?
why.
You are?
I'm not updated from the informant side. Today only I have filed the hotel. So neither I do have the copy.
And that's what I'm saying. You have filed a wakalatnama. You have been instructed to.
No, as per the- that I have gone through, whatever that. There is, it's true that it's the relationship going on for the last whatever the period is. And it went sour, south. But then there was a wrong on the part of the petitioner as well. Because he was harassing and taking extra advantage of me, my lord. So what about that?
I'll face the consequence, my lord, and I have already in the custody for 3 days, my lord. Custodial interrogation has been over. And the lordship that the notice was also not served to the parents, my lord. That is also there.
My lord, regarding notice, my lord, I have also inquired from the investigating officer, my lord. He has informed me that, my lord, his father and mother, my lord, they have refused to accept the notice, my lord. Then, my lord, the notice was sent to his residence, my lord. So in their residence, my lord, they have refused to accept the notice, my lord. Then one person, my lord, who accepted the notice on their behalf, my lord, he informed that he knows them very well, my lord, and he resides in their house, my lord. So there is no violation of section 48 notice, my lord.
The 48 says the accused has to nominate somebody or to parents. And then why the WhatsApp message, my lord? And why the notice was served to me, my lord? It was addressed to me, not to that person, my lord. 48 notice also. It was addressed to father, but the notice was given to somebody else. And that was not reflected on the forwarding report that I have refused to accept that part. That is an afterthought, my lord. When we have pleaded that part, this is an afterthought brought out by the investigating officer. That apart, my lord, already, my lord, I was in custody. I'll face the consequence, and regarding the assault part, that is available. It's a available part. And there is a delay of, my lord, 1 year, my lord, of the alleged incident. Thereafter, they have continued the relationship. She is accepting the money regularly. She has paid me back also. And one day, that too before lodging the FIR. And the letters, everything is there. Why my father custody is necessary? And the appearance of the learned counsel, my lord, on behalf of the informant, shows that the how grievance is there. Just because of the relationship has gone sir, man. Nothing more than that.
Is there anything in the case that Mr.
Yes.
Mr. Borua?
Yeah, my lord, so may
You
kindly
want to point out?
peruse our 183 statement, my lord,
Hmm.
which is very important, my lord,
Hmm.
and as well as the medical report, my lord.
Hmm.
He's 22 years, my lord. I am 20 years, my lord.
Mr. Borua, it says here, I mean, she has stated that sometimes, I mean, she frequents to the homestay. This, I mean, that's admitted fact with him.
Right.
And sometimes she agrees for some kind of relationship, sometimes she doesn't. I mean, what kind of this, I mean, statements of this?
And in between them, my lord, there are, my lord, she has also stated in our 183, my lord, then even when she refused, my lord, then also she was, my lord, not forceful, my lord, physical relationship, my lord. And thereafter, my lord, she was followed, my lord, and
She is a major, she has been
was
frequenting
mentally
frequenting the homestay willingly, and she goes there 1 year, they are having their relationship, she didn't do anything, and suddenly she has come up with this thing. I mean, this has to have some kind of motive. That was what.
And the second, madam, my second submission is that, my lord, he is on interim bail, my lord. He is granted, my lord, absolute bail, my lord. There are every possibility that, my lord, victim may be tortured again, my lord.
That
Because
means
when we will
I have to be in the custody for.
No, my lord, that I am not submitting, my
Then-
lord. The question is that, my lord, now he is on interim, my lord. Investigation is a very nascent stage, my lord. The investigation is yet to be completed, my lord.
Any other material?
My lord, at this stage, my lord, the victim card, there are two 186 statement, my lord.
When the
Kindly
164,
produce-
when her statement has been before the magistrate has been recorded, what remains?
My lord, 183,
What?
then, my lord, another witnesses of.
Can anybody I can change the statement now? When the magistrate has recorded the statement, what remains else?
There
And
there
we
are
can't
another
have
183
both.
statement, my lord. Lordship may kindly peruse, my lord.
So
Hmm?
it shows that the,
There are another 183 statement, my lord,
Hmm.
of the
that
witness.
means she is changing her version.
No, there are another witness, my lord.
Yeah, that means what, my lord?
Another witness, who?
That is, my lord, their friend, my lord.
It's marked here.
Just after her statement, my lord, 183.
So everything has been completed, my lord. Even the witness, I cannot pursue the witness to change the value statement also now. Or not statement. Medical done. How my release will affect the investigation now?
So BA decision multi-ticket holder. So ki BA decision.
Forty-seven, 48 notices are there.
It is there.
Yes, ma'am. 48 notice, Lordship, we are not challenging the 47 notice.
Hmm.
Lordship can see the 48 notice.
48 is.
Yes. Learned trial court also on the first day of, well, we have filed the application.
That he has come to the conclusion that he has been nominated.
Nominated and the no prejudice has been caused. That is the version of the trial court. Trial court has not said that it has been properly served. Rather, it has not, no prejudice has been caused to the accused because we have filed the bail application on that day itself.
No, he has come to.
Yes, yes. Finding is on in the page number.
The
my lord.
finding is that he said that it was nominated. He was nominated.
No.
Oh, where is the finding?
Finding, my lord, Lordship, can you see? Page 31. No, I took one. District level. No, page 39, my lord.
Page 39.
Para 19. Page 46. In my considered opinion, that is the opinion of the court, there is substantial compliance of 48 in this case because accused has been able to show that accused not been able to show that the due non-receipt of the notice under 48 has caused prejudice to them. So it is burden on the accused. It is other way around. The judgment of the Vihan Kumar said it is the duty of the prosecution to prove that the 48 has been duly been served. Whereas in this court says that the accused has not been able to show that due to non-receipt of the notice under 48 accused is prejudice. That's not the law, my lord. I don't have to show the prejudice, my lord. The accused is prejudice or that the family member of the accused has failed to take proper defense on time. The accused was arrested on 2/2/26. On the same day itself, he filed a bail petition before the learned so-and-so. Goes to show that the family members were well aware of the arrest of the accused. That is not the well aware of the, that's not the concept of the 48, my lord. 48 is the notice has to be served with the grounds and reasons of arrest. Where the notice, lordship, will found the page. We are aware of the arrest, my lord, but not the grounds of the arrest. Both are different.
48 notice where? Which page? Yes,
Page 35.
page 35.
It was addressed to my lord, lordship, kindly see, to Sri Rana Jaman. It was not to the nominated person. Now they are showing it that the accused has nominated somebody else. As the parent says,
refused to accept the notice. If that be so, then why it was served to Rana Jamant? We have already refused. It should have been addressed to the person who has been nominated by the accused. Now, who has Dilwar Hussain? The accepted by the Dilwar Hussain, page 36. If we have refused to accept the notice, my lord, why you have addressed to us? And you said we have nominated a person who is well known to them.
Well, I mean, is there any material showing that he has nominated?
No, my lord, question is that notice was issued in the name of the father of the accused person.
No, that's fine.
Not
I
that they refused to accept the
mean,
notice.
correct.
my
No,
lord.
is there any material on that?
Well, that is, no, my lord, lordship will have to go through the, my lord, case diary, my lord, the noting of the case diary, my lord. That is why, my lord, the IO has sent a person
And-
to his
and
residence,
lordship
my
can
lord,
see
to
notice.
serve the notice, my lord. Then also, my lord, parents had refused to accept the notice. Thereafter, my lord, this person was, the
No,
notice was given to.
is there any noting in the GD entry or whatever that it was refused, then it was given?
That I'll present, lordship may kindly.
And again, my lord, page 38,
Deosun City.
page 38, they are saying that it has been nominated to somebody else, but even then, they have forwarded a WhatsApp message on the last moment of my production before the trial in a WhatsApp message.
You see, I mean, if there is a noting,
Yes,
if
that-
there is a noting that they have refused it, I mean, if it is there. And what is this?
My lord, that is, my lord, submitted by informant, my lord. It is not a part of the case diary, my lord. That is why I am not relying on. my lord.
Okay. You just check if there any noting.
Because forwarding report does not say so, my lord.
Hmm.
Specifically that the accused has nominated. Because if I nominate somebody, my lord, then accused has to give in writing that I have nominated so and so. Because I am in the custody. So accused will nominate. Only on verbal thing will not do, because otherwise police will always say that the parents has refused to accept it or the nominated person accepted it. So that there has to be, because I am in the custody, you have served the notice on 47, and you could have also take my consent for nominated person. Whether there is anything by me, my lord, that I have nominated so and so in writing. Otherwise, whole exercise will be futile, my lord. Everywhere 48 will come that they have refused to accept. You will know, you will address to the parents, you will WhatsApp to the parents, and then you will say that no, they have refused to accept. Lordship, kindly see the forwarding also. The forwarding is the base part, my lord, which will show that whether any nominated person is there or not.
Page.
Page 22 onwards, my lord. They have written everything except regarding the service of notice, regarding 48. All details are there, grounds of arrest, everything. Why bail objection is there even. But regarding the service of notice regarding the 48, which is mandatory.
No, that's why I'm asking. I
Yes.
mean, if
Why
there
it
is.
is not in the forwarding?
If
It
if-
should have
if it
been
is-
the
if
forwarding.
anything is there. Mr. Boro, otherwise also see, I mean, from the facts, I mean, what we can see, it's a relationship between two persons, young persons. And it has, I mean, yes, there may be some accusations about, I mean, occasional, I mean, show of emotions by, I mean, whatever, I mean, slapping or whatever, all those things happen. Those are like, I mean, like some, I mean, emotional outbursts maybe. And the relationship went sour. That's admittedly is there. Now, whether, I mean, he's a student.
Both are.
The girl is also a student.
My lord,
Now,
this-
at
this-
this stage, whether, I mean, like, whether any benefits, I mean, the prosecution will gain keeping somebody inside. That is a question this court needs to
The
consider.
question is that, my lord, investigation has to go, my lord. because,
Yes,
my lord,
investigation, if he participates in the investigation, what is the problem?
participant, my lord, there is also chances of threatening the witnesses, my lord.
I mean, custodial detention is required for all investigations.
My lord, in this case, my lord, at least because it is a very nationalist, my lord.
See, they
Because
mature.
he has been given interim, my lord.
Both are law students, my lord, they knows the consequence.
See, recently Supreme Court has specific, I mean, very in a strong worded, I mean, language said about this kind of relationships and later on coming out with some complaints.
Yes.
Because, my lord, after getting him an absolute bail, my lord, he may not, my lord, incorporate also.
Do you have that recent case?
Yes.
I mean,
Yes.
that's,
It, no, paragraph.
I think Justice Nagaratna and Mr. Bhuya.
Yes, yes. Paragraph 9, my lord. In that case, there is a false promise of marriage. In my case, it is other way around, my lord. Rather, I have forced her to marry me, my lord.
Here, in my lord, question of marriage, but false or my true marriage does not come, my lord. There are allegations only of sexual
No, I am
abuse. my-
talking about the judgment.
Oh, okay.
In that judgment, even there is a false promise of marriage, but in this case, there is nothing that sort. Rather, I have, in her allegation, that I have pursued her to marry me, my lord, twice. This has been quashed, my lord. This particular case.
Here they came for quashing of the affair.
Yes, even the FIR has been quashed.
FIR has been quashed.
We are only for bail.
Mr. Borwa, see, what was the language? I'll just read out
My lord.
for your satisfaction. In our considered view, this is not a case where there was a false promise to marry to begin with. It's rather otherwise. A consensual relationship turning sour or partners becoming distant cannot be a ground invoking criminal machinery of the state. Such conduct not only burdens the courts but blots the identity of an individual accused of such heinous offense. This court has time and again warned against the misuse of provisions and has termed it a folly to treat each breach of the promise to marry a false promise and prosecute a person. So it has come in a very strong language, in fact.
That is true, my lord. In some cases, my lord, there are some my lord, false allegation acquisition, my lord. Here, my lord, what I have found, my lord, although there are some my lord, relationship was consensual, my lord, but there are also my lord, allegation is that, my lord, it was done by forceful act, my lord.
The trial will prove. Heard Mr. A.M. Bora, the learned senior counsel, appearing assisted by Mr. D. Bodya, the learned counsel for the petitioner, again for the accused applicant. Also heard Mr. R.J. Burwa, the learned APP for the state, as well as Mr. N. Anand for respondent number 2. Oh, no, sorry, for the informant. For the informant. This is an application number, you write, application number so and so. An FIR was lodged on 18/1/2026 by the informant. Alleging that the accused applicant got into a relationship with the informant after the informant meeting him at a common friend's birthday party sometime in 2000, sometime in the later part of 2024. It was it was alleged that in the month of February, met got in relation. Then they started dating each other. On 2nd of February 2025, it was alleged, that it was alleged that the accused applicant took the informant to a homestay near Chanmari and against her wishes, she was raped. Chanmari and taking her to the homestay when she refused to have any relationship, any physical relationship with him. He slapped her and thereafter raped her. It was alleged that sexual violence continued for multiple times thereafter. It was also alleged that on February 26, 2025, the accused applicant forced her to marry him as per the Hindu rituals against her will. Thereafter also, the accused applicant used to physically assault her. It was also alleged, it was alleged that on March 12, 2025, the accused applicant forced her to marry him as per the Muslim rituals through a video call with a Maulana. She was allegedly physically assaulted by the accused applicant many a times thereafter. It was alleged that lastly on January 8, 2026, the accused applicant, the accused slapped her and physically assaulted her, which caused severe bleeding and injury to her. On the very date, it was alleged that she ended her relationship with him. It was alleged that after that incident also, the accused applicant used to come to her residence and tried to meet her. He sent various video messages also, threatening her with dire consequences if he does not meet her. Full stop. On receipt of the FIR, the police registered dispute PS case number 29/2026 under the aforementioned sections. Full stop. When was he arrested? The police police arrested him on 2nd February 2026, and thereafter he was sent to judicial custody. Police remand. The police remand was sought for, no? Initially, how many days he was? Okay. And he was remanded to police custody for three days. Full stop. This court, wide an order dated 11/2/2026, has granted interim protection till today. No, granted interim bail to the accused applicant till today, and the matter was fixed for further consideration on the production of the case diary. The case diary in the instant case has been produced by the learned APP for the state. Full stop. The learned senior counsel appearing for the accused applicant submits that this is a typical case wherein a love affair between two young people has gone sour. He submits that the girl, being a 22 years old, and the girl being an educated 22 years old, has voluntarily got into a relationship with the accused applicant, who is 2 years younger to the girl, and thereafter voluntarily had sexual relationship with the accused applicant, which is apparent from the FIR itself. He submits that the statement under 183 has already been recorded of the accused applicant of the informant, and therefore the further custodial detention in the instant case may not be required. Full stop. He further submits that in the instant case, the section 48 notice of BNSS, which is mandatory in nature, has not been served while arresting the accused applicant by the police. In that count also, he submits that the accused applicant gets an unfettered right to be released on bail, full stop. Mr. R.J. Borua, the learned APP, on the other hand, submits that the investigation in the instant case is in a very initial stage, and the release of the accused applicant at this point of time may hamper the investigation of the case, full stop. He further submits that there are materials of, there are sufficient materials of physical assault as well as forceful sexual intercourse with the informant by the accused applicant is prima facie apparent from the statement of the victim, as well as his statement of victim, as well as another witness.
Another witnesses, and also, my lord, there are other witnesses also statement recorded, my lord. They have also implicated, my lord, as informed by the victim, my lord. That may be recorded, my lord.
I have stated so, but at least you have shown me that statement, the other with that friend.
The 183 statement.
One and the other witness. As far as section 48 notice is concerned, he submits that the notice was duly served, as the person who was served with the notice, section 48 notice, was being nominated by the accused applicant himself.
And known to the murder.
Accused applicant himself, as he was known to the family of the accused, applicant. Full stop. He further submits that the same had to be served on the nominated person, as the family members of the accused applicant refused to accept the same.
My lord. And there also threat of the, my lord.
Okay. In view of the aforesaid, the learned APP submits that this is not a stage wherein the accused applicant should be granted bail. Full stop. Mr. Anand, the learned counsel appearing on behalf of the informant, supports the submission made by the learned APP and opposes the bail, the prayer of bail at this stage. Full stop. This court has produced the case diary, which has been produced before this court, as well as heard the submissions made by the counsel appearing for the respective parties. Full stop. On consideration of the allegations made in the FIR, as well as the other materials brought before this court, it is seen that the accused applicant, as well as the informant, accused applicant and the informant were in a love relationship, and and there is no denial of the fact also that they are in physical relationship also, though there are allegations that on certain occasions the physical relationship might have been forceful in nature. It is also seen that the accused applicant is a student aged about 20 years, and the informant is also a young girl of 22 years of old. It is natural that in such kind of relationships, the occasional fights between and then it is natural that in such kind of relationships, the occasional fights can happen between the partners, which may not involve any intentional intentional criminal element. Just- It is also seen that the statement of the victim before the magistrate has already been, the victim as well as some other witnesses have already been recorded by the investigating authority. Investigating authority. Full stop. Having considered all the factual aspects, this court is of the prima facie view that this is a typical case wherein a consensual relationship, the relationship has gone sour after after passing of some time. Therefore, at this stage, this court is of the considered view that a custodial detention of the accused applicant is not something which cannot be avoided, and therefore the accused applicant should be given the privilege of bail at this stage. Accordingly, having arrived at the aforesaid prima facie finding, this court does not think, this court does not think that the merit of service of notice under section 48 of BNS is required to be gone in. In view of the aforesaid, it is directed that the accused applicant shall be released forthwith on furnishing of a bail bond. No, release forthwith already he has no. In view of the aforesaid, in view of the aforesaid, the interim bail granted by the accused, granted by order at 11/2/2026 is made absolute in terms of the aforesaid order. Next para, it is made clear. Next para, it is made clear that the accused applicant shall cooperate with the investigation and shall not try to temper or hamper with any evidence involved, which may be involved in the instant case. You cooperate with the investigation and.
My lord, I have one, my lord, submission, my lord. Let him appear before the IO, my lord, till completion of the investigation, my lord. At least, my lord, twice in a month, my lord. And my lord, he will never threaten the victim. Or
That
say
already,
word.
that he's not getting touch with the victim at all. That has been given
My lord,
already.
that has to be specific.
That has been given.
Because there are some.
And he will appear whenever and right in violation of any of the terms and any of the terms, any of the conditions given in the instant bail application. the same, the instant, and then the investigating and contracting authority will have a right to approach the appropriate court for cancellation of the same.
Let him appear before the IO, at least twice.
And that has been given. If it is violated, then I mean, you can always come and this has been specifically stated.
Obligation.
My lord, I'm sorry, my lord, when the matter was called for, my lord, I could not appear, my lord, I went to hospital, my lord. Well, this is a 3 years bail application, my lord, in connection with my lord.
The timing.
31, that matter, my lord, along with item 46.
Yes,
20
yes.
bottles found, my lord. And regarding this, my lord, that accused in item 46, who was arrested, he himself stated that he purchased those 20 bottles from the petitioner in item 31. Those 20 bottles were seized from the petitioner in item 46. Those bottles were
Bought
purchased
from this person.
Now the case of the petitioner, my lord, even the petitioner doesn't know who is that person, my lord. The accused, my lord, on whose statement, my lord, is on his statement, my name was indicated in the FIR, my lord. Not only even seeking a period bail in this court, my lord, even my name ought not to have been even inserted in the FIR also, my lord. My lord, the case of the petitioner, lord, you will find page number, my lord. Petitioner is a young boy of 23 years old. He is running a CSP, my lord. It is a banking service in the rural area of the petitioner's area, my lord. He is running a banking service, my lord, under the Airtel Payment Bank Limited. What you will find page number 16 is the, my lord, that authorization certificate to operate the bank, my lord. In that CSP, my lord, different person come for making transaction, withdrawal and deposit of money, my lord. The petitioner, my lord, after my lord, this confessional statement of this accused, my lord, I do not know whether the other accused is in item 46, my lord. Now, my lord, on the basis of his statement, my lord, the lordship will find, my lord, in the FIR portion, my lord, page number 12, what the police said, my lord. Lordship may kindly come to page number 12, my lord. Page number 12, this is the FIR, page 12, my lord. In the middle portion of the FIR, my lord. Third para from bottom, during preliminary interrogation, accused Manik Chand admitted that he collected the consignment from accused Rimu Sarkar, petitioner here, son of Akhtar Hussain of village Sialtari under Mankasur PS. Later, a house search was conducted at Rimu Sarkar residence, but nothing was found. And
Okay, you fled away. I mean, at this stage, I mean, this will be
the
difficult.
investigation is going on, my lord. Commercial quantity.
The commercial quantity of this thing, it cannot be. Heard Mr. J. Alam.
No, my lord, MA Islam, my lord.
MA Islam, the learned counsel appearing for the.
I want to place on judgment of the Honorable Supreme Court, my lord, and my lord, Surendra Kumar Khanna's case, my lord. Here, my lord, only on the basis of the statement of the co-accused, my lord, whether the petitioner can be
during investigation, my lord, not in during my lord, after the search, my lord, during investigation, it will proceed, my lord, as per co-accused.
Even my lord, immediately, my lord, immediately, my lord, the police raided my house and nothing was found, my lord.
But he fled away. Why?
Yes, obviously, my lord. Otherwise, my lord, I could have been arrested, my lord, by the police, my lord.
No, then he would have cooperated. Then
obviously, my lord, lordship may grant me protection, my lord. Under the protection of the court, my lord, I will appear before the IO, my lord, and I will record my statement. On daily basis, my lord, I will appear before the police station under protection, my lord. Lordship may grant me protection, my lord. Here, my lord, it is a case, my lord. Only on the basis of one person, my lord, 20 bottles of cough syrup, where from he purchased, even I do not know that person. He stated before police that he purchased from me, and on the basis of that statement, my name was inserted in the FIR, my lord. And immediately, my lord, police raided my house and nothing was found. Even not a single bottle, not even a plastic, my lord, label also was found in my house, my lord. My house is situated near the police station. I'm a local resident, my lord. If your lordship, my lord, consider my previous bail application, my lord, I will not only appear before the IO, even I will, my lord, appear before the trial court also. During the trial, if I am convicted, or the trial court will, my lord, accordingly decide the matter, my lord. Now in Surendra Kumar Singh Khanna's case, my lord, lordship.
Mr. Parasar, I mean, this co-accused statement only.
Co-accused statement, but investigation is going on, my lord. During investigation, it will proceed for co-accused statement only, my lord.
In my humble respect, my lord.
But that is the aspect Supreme Court has stated that in the bail matters it has to be considered.
Bail matter, my lord.
But because, I mean, if you have any other material to linking him or something which shows that like, his involvement,
After the statement.
is there anything?
After the statement of that accused, my lord, police search him, search his house, my lord. So up to that much, my lord. It is not found anything, my lord. He was not there in the house.
Lordship,
Yeah, let him go, Mr. Parasa. I mean, see, I mean, this goes against that, only the co-accused statement.
My lord, co-accused statement, yes, my lord. At this stage, my lord.
The Tufan Singh, the other cases, all these cases, I mean, recently also, recently also another case, it is specifically stated that, he gets a right to bail only on the basis of the co-accused.
But Tufan Singh, my lord, basically, my lord.
No, no,
Not only, my lord,
not only
investigation
Tufan Singh,
stage.
there are certain other cases also. I'll give you this case number. See, I think you were not there, who was there?
51, my lord, your lordship referred to a judgment of the Honorable Supreme Court.
Just a minute, just a minute. See, the statement of Supreme Court is that appellant herein has arraigned as an accused on the basis of a co-accused statement. As to actual complicity of the appellant is an issue which will have to be thrashed out during the trial. And such appellant would be entitled to being released on bail. That is the language that has been used.
My lord.
Heard Mr. M.A. Islam, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APP for the state. This is an application under so-and-so, right? An FIR was lodged on lodged on 23/11/2025, alleging that on receipt of certain information on 22/11/2025, the police, while conducting a NACA check, one accused person, namely,
Manik Chand, my lord.
Manik Chand, was apprehended with his scooter, with his
It's a two-wheeler bike.
no, with his two-wheeler, and on checking the two-wheeler, the police recovered 20 bottles of cough syrup, 20 bottles of cough syrup. In bracket, you can write narcotic and psychotropic substances, cough syrup, from the possession of the aforesaid Manik Chand. Full stop. On receipt of the FIR, the police registered Mankachar PS case number 157/2025 under section 21 in bracket small c /29 NDPS Act. What about section 37, Mr. Parasar? NDPS?
Yes, embargo is there, my lord. Embargo will be there, my lord. The commercial quantity, my lord.
Section 37 condition, those are applicable only in case of recovering of direct position,
Conscious
recovering of
position.
position of the contraband. Here, only nothing was found from the position of the petitioners. And moreover, the petitioner will not repeated the same thing, neither even committed the same thing, nor will repeat the same thing, because only on the basis of the co-statement of one.
But I mean, you're charged with that.
Such only, my
mean,
name is inserted.
FIR charges, FIR, you have been also accused of the same thing. Criminal conspiracy is there,
Well, criminal conspiracy is there, but no material is there, my lord.
27 is there.
Only this is the, my lord, FIR was lodged by the police, my lord. FIR was lodged by the police himself, my lord.
Okay, key लिख लो रास्ता. Last line. So file. During the investigation. During the investigation. The next, the learned counsel. The learned counsel, appearing for the accused applicant, submits that the accused person, the accused applicant has been named in the FIR only on the basis of the statement made by the co-accused, that is Manik Chand, full stop. Is further submits that immediately after.
Online, that accused person, earlier accused person Manik Chand, escorted the police party to the house of this petitioner, and then police search. He escorted police party to him, to his house.
The basis of the Manik Chand, and immediately thereafter, police searched the house of the accused applicant. However, nothing could be recovered from the house of the accused applicant. In view of he submits that in view of the ratios laid down, in view of the ratios laid down by the Honorable Supreme Court in the case of Tufan Singh versus State of Tamil Nadu, reported in so and so. And this is, keep it blank, I'll just give it to and so and so. Only on the basis of the statement of the co-accused, the co-accused, a person cannot be detained by the police. Full stop. In absence of any material, any substantive material linking the accused person to the alleged offense, only on the basis of an implication by the co-accused cannot be a ground for arresting a person. Also, in view of the aforesaid, he submits that the accused applicant should be allowed to go on bail. On the other hand, the learned APP submits that in the instant case, the accused, the main accused, that is Manik Chand, has immediately uttered, on his arrest, immediately uttered the name of the accused applicant, and thereafter police, and thereafter he escort the police to the house of the accused applicant. He further submits that, therefore he submits that, mm, submits that, therefore he submits that the involvement of the
At this stage of investigation, bail may not be granted.
the involvement of the accused applicant cannot be ruled out in the instant case. And therefore, at this stage, the accused applicant should not be granted bail. Full stop. This court has heard the submissions made by the counsel appearing for the parties, and after considering the facts of the case as well as the ratios laid down by the Honorable Supreme Court, this court is of the considered opinion that the accused applicant should be granted bail at this stage. Granted bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant, the accused applicant shall be released on bail on furnishing of a bail bond of ₹50,000 with two securities of like nature, subject to the satisfaction of who?
Arresting authority.
OCL, arresting authority, subject to the following conditions: that the accused applicant shall appear before the investigating officer within 7 days of passing of this order. The accused applicant shall present himself before the IO as and when required. The accused applicant shall surrender his PAN card, copies of his PAN card, Aadhaar card, driving license, and passport, if any, before the investigating officer. The accused applicant shall not try to influence any witness that may be involved in the instant case in whatsoever manner. ঠিক আছে? In your requested direction, the instant AB application is disposed of.
Item 60, admission.
3:30 বজাত মই 5 মিনিট আগত উঠিম কিবা এটা কামত আছে। None appears for the petitioner when the matter was called for. Let the matter be fixed after a week. After 2 weeks.
May I please also? My lord, in this case, PCR has already been received, my lord. It is a criminal petition, my lord, under section 520 for quashing of the FIR and infant charge sheet, my lord.
The case, what about service?
Please complete. It is FIR page number, my lord, 23.
But as it is service not shown, my lord, in the court list, my lord, I have not gone through the, my lord, scan copy also, my lord. I think private party will come.
Private service is completed. And service is completed from the private party.
Washing of charge sheet, my lord, have to go through the.
Yes, ma'am. As well as FIR is in page number 23, my lord.
So, Parasar, you wanted to go through it, what?
My lord. Because washing of charge sheet, FIR and charge sheet.
Who is this Bilal Ahmed? He is the informant. Private party?
Private part, yes, sir.
Why have you made him party?
Bilal Ahmed, my lord.
Who is he?
My lord, he is the informant,
He is the informant.
my lord. Allegation, my lord, it's a pre-matric scholarship regarding anomalies in pre-matric scholarship. It's all these things, my lord, process were going on online process, my lord. Petitioner has no any hand, my lord, in this, in the allegation, my lord. Petitioner is a DO, and after completion of the process, application process, my lord, petitioner joined in the, joined as DO, my lord. And petitioner is the district level nodal officer of the scholarship scheme, my lord. It's a central sponsored scheme.
Take list of 50th from 50th.
I have annexed the, my lord, SOP of the scholarship, scheme of the scholarship, my lord. Its details, my lord, stated the process. my
Let him go through it. He's saying that
My lord.
sometime, I mean,
My lord.
heard Mrs. So-and-so
Issue.
on the prayer of, also heard Mr. K.K. Parasar, learned APP for the state. Let the matter be fixed on. When do you want, Mr. Parasar?
Next week also, Malab, we have to go through.
Let the matter be fixed on 24th.
My,
24th.
yeah, yes.
Hmm.
18 and 19, my lord.
Hmm?
18 and 19 also, my lord. Same person, my lord. Lord, I paid for lordship.
18 and 19.
And 19. Lordship, may kindly take up the matter 19 first.
Why two petitions?
My lord, 2 FIRs.
My lord, we have filed the objection. It is not in the record.
You are appealing for whom?
I am for informant. My friend is representing state.
Item number 19, my lord. That is, my lord, criminal petition number 1459, my lord. Lordship, may kindly turn to page 19, the FIR, my lord.
He's saying he has filed an objection that is not there,
Yes, my lord, we have received the copy, my lord.
but it's not there on record. We'll fix it some other day. Heard Mr. N.J. Datta, the learned counsel appearing for the accused, for the petitioner. Also heard Mr. K.K. Parasar, the learned APP for the state, as well as Mr. S.C. Biswas. You are appearing in item number, both items? Appearing for the respondent number 2. Yeah, Mr. Biswas submits that an objection in the instant case has been, you have filed what, affidavit in opposition?
Affidavit in opposition.
Filed an affidavit in opposition in the instant case, which is not found to be on record. Let the matter be fixed on. When?
Any date, my lord? No,
As per your call.
next week?
26th.
Yes.
26th.
26th, like, my lord? No, can it be, my lord, he is will be not there, my lord, on 2nd of March, man.
Okay, 2nd of March.
2nd of March. I'm obliged.
Item 47, orders.
In this matter, lordship, on the last occasion, TCR has been called for and these are before this court. So I pray to fix the matter for hearing lordship. Because,
Okay, heard MS N. Chaudhary, the learned counsel, appearing for the appellant. Also heard Mr. K.K. Parasar, the learned APP for the state. TCR in the instant case has been received. Let the matter be fixed for hearing in the month, in the first week of March.
or after 4 weeks.
In the second week of March.
Yes, lordship.
none appears when the matter was called for. Let the matter be fixed after, after 3 weeks.
May I please the lordship? My lord, from the beginning, there is a direction.
Yes, I mean, you were supposed to pay 25%.
Yes, my lord, I have.
You have paid it.
Yes, my lord.
You have paid it.
Yes, my lord, 1,87,500 pay by demand draft, it is deposited to the office of the Registrar General, my lord, Gauhati High Court. Copy to the.
May it please, Lordship. I am appearing for the respondent number 2 complainant in this case, Lordship.
As part of direction, the money has been deposited.
Yes, Lordship.
So we'll fix the matter for hearing then.
Lordship, in the meantime, the complainant respondent may kindly be allowed to withdraw that amount.
Hmm?
Lordship. The complainant respondent number 2 may kindly be allowed to.
It is to be paid to you only, right?
Lordship.
And as per.
Registry may kindly be directed, Lordship, to release the amount in favor of the complainant respondent number 2, Lordship.
Petitioner also appeared before the court, my lord, trial court, and furnished bail bond, my lord, money bail, rupees 5,000 is his release on bail, my lord, on,
He's released on bail.
yes, my lord, on 13th February, my lord, just after depositing the money, my lord.
Lordship, appellant were convicted by the trial court. Thereafter, they preferred the appeal before the learned district says that was dismissed, Lordship. There is concurrent finding is there, Lordship. A so that may kindly be fixed so that the matter may kindly be heard. That was convicted under section 138 of the Anna Act, Lordship.
Okay. In term, heard
BRA Sultana.
MS BRA Sultana, the learned counsel appearing for the petitioner, also heard Mr.
S.K. Agarwal.
S.K. Agarwal, the learned counsel appearing for respondent number
2.
Respondent number 2.
Complainant.
Mr. Parasar is also there? Huh? Yes, Mr. K.K. Parasar for learned APB for respondent number 1. In terms of the order, which was the order, initial order? 28/7.
Lordship.
In terms of the order dated 28/7/2025, an amount of rupees 1,87,500. Whatsoever লিখি পারে এটু? By way of a demand draft bearing number 946684 dated 22/12, right, Nick? What dated?
20.
Dated 22/1/2026. Is it correct? You don't have the copy?
I have no copy, my lord, that is the copy, my lord.
It seems it is 22.
Original is deposited, my lord, for the office, my lord.
Bearing number so and so कर दो, so and so. By the petitioner before the Register Judicial stroke Registrar General, Gauhati High Court, Gauhati, on 12/2/2026. The learned counsel appearing for the petitioner submits that on submission of the aforesaid amount, the petitioner appeared before, petitioner sought for,
Appeared before the trial court.
be-
my lord.
before the trial court, and he has been already released on bail. Full stop. The learned counsel appearing for the respondent number submits that since the money has been paid, the same should be allowed to be withdrawn from the register, coming back at judicial Guwahati High Court. Full stop. The prayer for withdrawn is allowed. The respondent number 2 is allowed to withdraw the aforesaid deposit from the registrar in bracket judicial stroke registrar general following the due procedure. Full stop.
But produce the ID card.
Now, whatever is there, the due
Aadhaar
procedure, full stop. Since the matter is ready for hearing, let the matter be fixed after 3 weeks.
The date में कैंडी की fix हो सकता है.
After 3 weeks, they withdraw it, then after 3 weeks, March.
Definitely.
Is there any? No. Fine.
Obliged also.
itu matikle barisma pura kayalde na. Side in the bajilde. 5 minutes, I just need to come back. 5 minutes. From the petitioner's side, let the matter be fixed after 3 weeks.
41.
May I please, your lordship? Lordship, stay has been taken, lordship, on 11th February. Lordship, kindly awaited for service report.
Service report awaited. Let the matter be fixed after
Interim.
3 weeks. Interim order so passed earlier shall continue. Put her name also, her presence. Appears for the petitioner.
42.
Made previously lordship, my lord.
Yes.
My lord, here, my lord, person to order to the 13/10, my lord. We have taken the fresh steps upon the respondent number 2 on 14/10. So, my lord, that may be awaited, my lord. Service report may be awaited.
Heard Mr. B.K. Das, the learned counsel, appeared for the petitioner. Service report on respondent number 2 is awaited. Let the matter be fixed after 2 weeks.
Yes. Obliged.
53.
May I please, your lordship?
Yes.
Service report awaited as per office note.
Heard Mr.
R.L. Sutia.
Sutil Learned Counsel appearing for the petitioner. Service report on respondent number
2.
Service report on service report is awaited. Service report of service of notice on respondent number 2 is awaited. Let the matter be fixed after 3 weeks.
This is the, my lord, criminal petition filed by the state of Assam, my lord.
Huh?
Here, my lord, criminal petition filed by the state of Assam, my lord.
Hmm.
Here, my lord, we have filed an application for continuation of the delay, my lord. In this case, my lord, notice has already been issued, my lord.
Service report is awaited.
Awaited, my lord.
We'll await for some time. Service report is awaited in the instant case. Instant case in respect of respondent number 1. Mr. R.J. Borua appears for the state. Let the matter be fixed after 3 weeks.
My lord.
Worship, as per last order, Worship, TCR of GR case number 4585 was called for. Worship.
Has it come?
TCR, my lord.
Or wait.
It is one with TCR, my lord.
Hmm?
For 52, my
No,
lord.
no, another TCR. That was appellate TCR.
Huh? Not received, my lord.
Otherwise, a report was called for. Worship.
Records of GR case number 4585/95 is yet to be received. Let the matter be fixed after 3 weeks. Present heard so and so also.
Lordship, on last occasion, one of the court asked me why I filed this IA lately. And therefore, my lord, I filed today on additional affidavit that he was, my lord, under medical treatment due to kidney disease, my lord. And last on 2025, he was discharged, admitted on 17th. And thereafter, my lord, on 20 August 2025, DJS are done, my lord, because pipe was, my lord, kidney pipe was removed.
May it please your
Therefore, my
lordship,
lord, he is
they filed
financially-
this petition after 7 months. The order was on July. And now on last date, there was in January, 28 January, there was a last date. They did not file any IA. And they filed this IA on Feb. Right now, they are filing this affidavit.
No, lordship,
7 months delay.
my lord, take recourse, section 403, my lord, all correspondence section 362. There is no bar and limitation, my lord. And my lord, only pair, my lord, we dispense with considering the primacy case, the deposit of 20% is to be dispensed with. And because of, my lord, it is admitted fact so far, my lord, if lordship kindly have a look, page 42 in my criminal revision petition, it is admitted fact only 14,000 is liability. So if I deposit 60,000, it is, my lord, prejudice and unjust, my lord. Page 42, the cross part of the petitioner, it is clearly mentioned, my lord, I have to pay an amount of rupees 40,000 as outstanding amount towards the complainant as on today. And that has not been corroborated. No question was put.
No, what is this discharge? Your discharge on 27/2025 only.
Yes, lordship.
Then
After 7 months, they are filing your substitute.
No, he was in prolonged.
What prolonged?
Trouble, my lord. And
nothing.
It is, my lord, now.
Yeah, you have been released on 27/2025 only.
Yes, my lord. Now, my lord.
And you went to the
thereafter, my lord,
hospital
on
and you took this.
28, 2025, he was also on bed rest because the internal pipe was there, my lord, on which was done on 20th December, August 2025. My lord, it is kidney related disease, my lord, that may be allow, my lord. Otherwise, my lord, so far this eye is concerned, it is, my lord, maintainable, my lord. So far this one Supreme Court decision as because here, my lord, here, my lord, when there is a comprehensive evaluation focusing on the core legal validity involved, then this is maintainable, my lord. Paragraph 8, my lord. Because here substantive.
But this is not convincible, Mr. Bhuya.
Which one, lordship?
That, I mean, that the medical certificate you are giving.
No, why I filed this I lately, because there was.
So, I mean, this IA is liable to be dismissed.
They let me file, my lord, the objection, my lord.
No,
Then, my lord.
no, your worship.
Let
They
me
could have
file
filed in
objection.
January, your worship. The
You
last,
file an objection
Because
this-
they want to
this
file.
Ganesh Patil
on,
case
on
is
the
for-
IA. You file an objection in the IA.
your worship.
Then we'll consider. Because, I mean, this IA has to be allowed. Then only, I mean, the other matter can be heard.
The lordship, the IA could be filed in month of January itself.
That's what I'm saying. You file an objection to this. Heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr.
MJ Hazarika.
Zarika, the learned counsel for the
Respondent 2.
respondent number 2. Respondent number 2.
This one, no, two.
Respondent number 2. Mr. Hazarika submits that he would like to file an objection to the IA filed by the petitioner.
Petition.
Prayer is allowed. Let the matter be fixed after 2 weeks. Let the matter be fixed on 10th of March. 10th of March. You file an objection in between. And this has to be considered, then only the, his main petition can be heard.
I know. 45 hearing.
Yes. Mhm.
It is a very old pending petition, 372. It is a petition for appeal against equitable matter. The other person is already entered appearance. I think their name is also shown, but they are not coming. In our earlier occasion also, I did not find them. What's the name? 45.
Heard Mr. S.C. Biswas.
Mukund Kumar.
S.C. Biswas, the learned counsel.
Arsipal name is shown, man.
S.C. Biswas, the learned counsel appearing for the petitioner. However, none appeared for respondent number.
2.
Respondent number.
2, my lord.
Now, there are other respondents also.
Yes, other respondent.
Nobody has appeared.
Nobody. Yeah, he is 1 to 5.
None appeared for respondent number 1 to 5. 1 to 5. Did they appear earlier?
Yes, they appeared.
Huh? You take fresh steps now. Nobody has appeared, it seems.
Yes, Okalanama is there. Okalanama is there, I have seen. In College also RC Paul for 1 to 5, which is Mrs. S. Roy, 1 to 5. There are 2 lawyers.
Okay.
Item 45.
You know, Mr. Arsipal,
Yes, I know. I'll inform him.
you'll intimate him that why he is not appearing.
Sure.
Taking into consideration that the matter relates to the year 2014, let the matter be listed. In the second week of March.
Yes.
In the second week of March for hearing. If they do not come, then you please intimate that then,
Same room.
if they do not come, then we'll hear it.